I'm Vinny Politan. I'm a former prosecutor. I'm a lawyer. Don't hold that against me. But here's what I'm doing now. I am the anchor for Court TV, the network that will bring you your front row seat to justice, live gavel-to-gavel coverage of the nation's biggest trials. We relaunch in May of 2019.
Days in jail. Apparently you have an attorney to represent you, Mr. Calderon. Ms. Brito, do you wish to be heard regarding any of these matters?
Judge, I would just, Mr. Calderwood is a lifelong resident of Brevard County. He has ties to the community, including his parents, a wife, and children. He's a resident, and I'd ask that you reduce the bond to $15,000 on both charges of the felonies and a bond schedule on the marijuana and resisting.
Based on the nature of the charges and the prior record, I'll deny your request to reduce the bond. I'll set an arraignment date. Do we have a date for that? All right. And I don't need to appoint counsel. Anything else I should address? If he is released on those bonds, conditions will be no contact whatsoever with the alleged victim. That means no phone calls, no emails, no personal contact whatsoever. Do you understand that, Mr. Calderon?
Yes, he understands, Judge.
Any further requests from the state regarding this case?
I can't hear her. Judge, first of all, I can't hear her.
Sorry.
Okay.
The information indicates that these individuals were roommates, and the state requests no return to the residence as well.
Well, Judge, let me speak to that. The alleged victim in this case was not a resident at that home. He was someone who was sleeping on a couch, from what I'm understanding, and therefore he would have no property rights to that home. So by not allowing my client, in the event that my client posts a bond, to return to his residence that he has a rent for, he has a lease for, that he lives at, would be inappropriate of the court. The person who's alleged to be the victim in this case, as I said, has no legal rights to that house at all whatsoever. So it would be an unjust enrichment to that person in order to allow them to live there rent-free, lease-free, legal agreement-free.
All right. I will, go ahead. I will leave the condition as it is, no return. You may apply to the court for a hearing on that issue, and then the victim would be able to be contacted and be present and have some say in what's going on. Without further information from both sides, I can't make a decision as to that issue. Certainly, if you are able through other means to find out that the victim is no longer staying at that residence, then you can apply for a modification of that condition because the victim no longer lives there.
Right. It says it right in the police report that he returned to his temporary residence. So
that still is a residence.
okay.
All right. So I'll leave those conditions as they are.
Okay. Thank you very much, Your Honor.
That's all.
Judge, also on the next case, Derick Munnings, I can tell the court.
Just a moment. Leaving those bonds as they are, yes.
Right.
I'm sorry, you have another case?
I don't have another case. I just want to advise the court, as a friend of the court, that Mr. Munnings is also a co-defendant in this matter, and a public defender has already been appointed on another case, on another co-defendant in this matter, so you probably have to appoint regional conflict after the public defender stands in for today. Thank you.
Derick Munnings, please state your full name.
Derick Anthony Munnings.
You've been arrested and charged with aggravated battery, sexual battery of a victim over age 18, and kidnapping with inflicting bodily harm. I believe the aggravated battery is a secondary felony punishable by up to 15 years in prison, and the other two are first-degree felonies punishable by up to 30 years in prison. I've reviewed the arrest form. I do find probable cause. I don't need to, though, because there was an arrest warrant. That's not necessary for me to do that. Do you have an attorney to represent you, sir?
No, I asked for a public.
Do you want one?
Yes.
Can you afford to hire one?
Yes, but I haven't got a chance to make the call for that.
So you can hire a lawyer?
Yeah, but I'd have to file my taxes and get the money that I have at home.
So you're not going to be able to hire a lawyer unless you're able to get out and do your taxes. So you're,
Yes.
are you going to be able to post your bonds?
I'm not sure how much my bond is right now.
Well, they're currently 50,000, 35,000, and 35,000.
Is there any way I can get it lowered?
I'm not going to change those bonds, sir. They're reasonable bonds based on the charges. I'll go ahead and appoint a public defender or conflict counsel. Is the public defender aware of the conflict that was stated by Ms. Brito?
I'm not, Judge. I mean, I don't know if there's a co-defendant in this case or not, so.
Well, Mr. Munnings and Mr. Calderwood are co-defendants.
There was a
Then-
third person on the docket yesterday that was appointed to your office.
Yes.
And that would be a conflict, yes.
Okay, so I'll go ahead and appoint conflict counsel for Mr. Munnings.
Is that going to be RCC, ma'am?
Yes, sir.
And same conditions that I essentially applied to Mr. Calderwood, including the no return, no contact. Set the arraignment for February 8th at 8 a.m. with Ms. Judge Ingram. State request anything further in this matter?
No, Your Honor.
That's all, Mr. Munnings. And was there another one, third one? Right, okay. So it was just 3, not 4, okay. So there's some new people coming in, so I'll need to do the, but I don't need to do it. Yeah, okay. Angeli Blessy. Tell me. Just say, great. That's fine. Please state your name.
Angeli Blase Zakalezny.
All right. You've been arrested on charge of aggravated battery, domestic violence. I've reviewed your arrest form. I find probable cause for the arrest. Do you have a lawyer to represent you?
No, ma'am.
You want one?
Yes, please.
Can you afford to hire one?
No.
That's what I'd like to say. She qualifies. No problem. I'll find that you're indigent, appoint a public defender to represent you. Do you have a place to live other than with the alleged victim?
Yes, at my home, my husband, who was apparent, I'm not going to try the case. Okay, my husband is not supposed to be at the house unless with my permission because he's convicted of domestic violence against me, and he's only allowed to be there if I allow him. If I had remembered that last night, I would have just called the police or asked him to leave at the time. But I was being attacked, and I defended myself, and I left. And my phone had been crushed and burned, so I went to the neighbors and called the police for help, and I ended up getting the charge.
All right. Well, I can't make all those decisions today. I just need to know if you have a place to live other than at the home with him. I can make some release conditions. If you
Yes, I do. I could stay with a friend. But I would like to have permission to return to my home since he is on probation still, and he's not supposed to be at the home without my permission, so I can return home. He's a commercial fisherman anyway, and he won't be here past Thursday because he has to go back out to sea. He's 54, very strong.
ma'am.
I know. Sorry, excuse
Does the
me.
state wish to be heard regarding bond?
There's a state request, $20,000. Ms. Blase is on probation right now in case 17-11339, a DUI case. She was just placed on probation a couple of months ago. And although there's no on-site noted, the state would request a slightly upward deviation from the $15,000 to $20,000.
All right. She also has a court date tomorrow.
Yes, I do, in Titusville.
Just need to ask them to let Titusville Court know that you're in custody because the jail list might not show that as of tomorrow morning.
May I request to have my bond reduced so I can get out and take care of my home? I have taxes and many things to do with the house. I'm the only one there most of the time.
Well, lots of issues here, ma'am.
Well, even to get out and be able to handle my affairs, whether I'm at the house or not.
But I'm going to leave the bond set at $15,000 cash as surety. Condition, no contact with the alleged victim. No return to the home except one time with law enforcement to get your personal items and to confirm whether or not the victim is actually living there. If the victim's living there, you may not return to the house other than the one time with law enforcement until further order of the court. I'll set the arraignment on February 8th at 8 a.m. with Judge Ingram.
May I ask for Judge Garagofalo?
No, ma'am. You have a court date set for the arraignment for the felony. It depends on whether the state pursues the felony or not, which they may or may not do. Which judge will be assigned to the case. Any further requests from the state?
No, Your Honor.
That's all, ma'am. State your name, please.
Amanda Briggs.
Been arrested and charged with battery by a person in prison or jail facility. I find probable cause for your arrest. Do you have an attorney to represent you?
No.
Do you want one?
Yes.
Can you afford to hire
No.
one? All right. Does she have public defender on other cases? Because the other defendant, who's the victim in this case, is
Ma'am,
also in custody. Yes, ma'am?
I'm sorry. Is it okay if I say something?
If it's about the facts, there may be a concern.
It's not exactly about the facts.
All right.
I just finished serving a 6-month on a 9-month BOP charge, and I was supposed to EOS yesterday. The alleged victim and I both do not want to press charges. I've never had a violent charge before, and I have a job lined up. I need to get out. If maybe I was thinking maybe I could get a ROR or something like that. This whole thing was a misunderstanding. Like I said, neither one of us wishes to press charges. We're both here today. And I really need to get out to take care of my affairs.
Okay. And what about the next one on the list, Ms. Woodline? I don't want to create conflict if I can avoid it. I could appoint PD on both if they both qualify and then just let them withdraw the one they need to withdraw on. But we know there's a conflict. What's the state's position regarding her request?
We defer to the court.
Does the record support the fact that she was ready to be released? Okay.
All I can tell is that she was in custody since August 14th, 2017.
Can you look this up or anything?
I'm sure if you have the case number, the clerk would be able to verify what the sentence was on that case
Well,
number.
she's saying it was 9 months and she was
My-
getting to get out at 6 months, probably because of.
My end of sentence
Correct.
was to
That
be
would-
yesterday.
I mean, that would be consistent with typically what the jail is giving as good
I
and gain
understand that,
time.
but I can't figure that out.
Well, the only people that would actually be able to fully confirm what the EOS date would be the Brevard County Jail.
All right.
For what it's worth, her disposition was on June 2nd, and she received 270 days. I'm sorry. No, on the VOP, the disposition was on September 15th. She received 270 days with 59 days credit time served at that time.
I'm sorry, but I was told that my end of sentence was to be on the 14th of this month, which would have been yesterday.
I understand that you're probably correct. I just
Okay.
need to verify.
I
these things.
understand.
I would really like to believe every single one of you what you
I
tell me,
know.
but, you know, I've been doing this a long time. I really can't do that.
I
I have to
understand.
verify. Okay. That's fine. Okay, that's fine. Thank you. I'll reduce the bond to $500 cash as surety. Condition no contact with the alleged victim. If you want counsel, I'll likely appoint conflict counsel unless the other party waives counsel because she has public defender in other cases. So we'll figure that out in just a few moments and put that on your paperwork.
Thank you.
That's all.
Thank you.
Ms. Woodline? You're Francois Woodline?
Woodline Francois.
Woodline, okay. You've been arrested and charged with the same thing?
Yeah, I'm the other person in the case. I don't want to press charges either. So.
Pardon me?
I'm the other person in the same case. I don't want to press charges.
Okay. Well, it's going to be up for the state to make that determination, ma'am, not me.
All right.
You do have a right to have an attorney. If you can't afford one, I will appoint one for you. Would you like an attorney in this matter?
Yes, ma'am.
Can you afford to hire one?
No, ma'am.
She qualifies. I'll appoint the public defender for you and then affirm that the conflict counsel is for the other young lady. On this case, I'll set the bond at $500 cash as surety. Because you're still in custody on other charges, you probably won't be released until those other charges are resolved. And set your arraignment date. You know, I don't know if I gave.
Well, I'm gonna be going back to another county, so. I don't know.
Well, they probably won't take you back to the other county until you resolve these charges.
I have a court date coming up in the other county, though.
Pardon me?
I have a court date coming up in the other county, though.
Why can't I find her on the docket? You know, it's supposed to be alphabetical, and I can't find her on the docket. Oh, her last name is Francois. I'm sorry. Thank you. Is Francois your last name or first name?
Francois is my last name.
Thank you, ma'am. It shows an arraignment date of February 20th with Judge Baker in Titusville. You can talk with your public defender about getting you set up sooner if you want, or getting it
Yeah,
combined with
because
the other
I have
cases.
a court date in another county. I was only supposed to be here for my court date tomorrow. So,
Okay, what's your court date tomorrow on?
the cases that I have here,
Well, then tell your,
because this is from last night.
I know, tell your public defender what happened and see what maybe they can work something out to get you in sooner. And that's not necessarily him, it'll be the one that you see tomorrow in court,
Oh, okay.
all right?
All right, thank you.
And I found probable cause. If I forget to find probable cause, ask me. Are these ones ready for me to sign? Are you Jed Henderson?
Yes, ma'am.
You've been arrested on a charge of violation of your community control or community supervision, and a new charge of battery and resisting without violence. Do you have an attorney to represent you?
No.
Do you want one?
Yes, please.
Can you afford to hire one?
No, ma'am.
I'll appoint a public defender to represent you. I'll find probable cause for the arrest in both of these cases. Looks like your bond on one of them is set at $2,500 for violation of the community supervision. And on the new case, it's set at $500 on each of the resisting charges and no bond on the domestic violence charge. State wish to be heard regarding the no bond status?
Your Honor, Mr. Henderson has a lengthy criminal history, including some felonies. The state requests $1,500, no contact with victim or return.
All right. I'll leave the bonds on the other ones set as they are. I'll set the bond on the new charge of battery domestic violence at $2,500 cash as surety. Conditions: no return to, no contact with the alleged victim, no contact with her, no living with her. If you and she are residing in the same residence, you may return one time with a law enforcement officer, only to retrieve your personal items. And set your court dates. Looks like you already have a court date with Judge Ingram on a bond hearing and a docket signing with Judge Ingram. Was the bond hearing is probably a motion to revoke the bond. I think there was a motion by the state to revoke the bond, so those court dates can stay the same.
Which were what, Your Honor?
You have a court date on January 18th with Judge Ingram. It says it's a bond hearing, but from my review of the case, it looks like they were asking to revoke your bond. And February 6th, you have a docket signing with Judge Ingram, which is prior to the trial in that case. Your new case, you're going to have arraignment of February 8th with Judge Ingram.
Your Honor, may I ask, in the event that the alleged victim wanted to drop these charges, what
Those
does
are
that
questions you
entail?
can ask your lawyer, sir. And it's up to the state to determine whether they proceed with the charges, whether or not the victim wishes to proceed.
She never wanted to proceed in
I
the first
understand
place.
that. I read your paperwork. It looks like somebody witnessed it, and the police officer arrested you, and pursued the case. So they can pursue even if the victim doesn't want them to pursue, because it doesn't require the victim's participation if there's other witnesses to prove it. Those are issues you can discuss with your lawyer, sir. Do you need anything else from me? All right, that's all, sir. Just give myself a paper cut. Slitting my wrist with the paper. Are you Raymond Kelly?
Yes, ma'am.
You're charged with battery on a law enforcement officer by an inmate. Do you have an attorney to represent you, sir?
No, ma'am.
Do you want one?
Yes, please.
Can you afford to hire one?
No.
I'll appoint a public defender to represent you. I read the arrest form. I'll find there's probable cause for the arrest. Bond is currently set at $5,000 cash as surety. And he's was just in custody within the last couple of days. The court date of February 8th. Is there a reason to have two separate court dates for arraignment?
Based on the schedules that were provided by those individual judges.
Yep.
Give us times that they want us to have.
All right.
And honestly, once the public defender files a notice of appearance, it'll go into to be notified status until the state makes a filing decision, so.
All right, so I've appointed the public defender. I'll set your court date on this case, February 20th, with Judge Baker in Titusville, and leave the bond set at $5,000 cash as surety. That's all, sir. Got it? Jonathan Long,
Yes, Your Honor.
you've been arrested on a charge of battery on a law enforcement officer and resisting an officer without violence. I've reviewed your arrest form. I find probable cause for the arrest. Do you have an attorney to represent you?
No, ma'am.
Do you want one?
Yes, ma'am.
Can you afford to hire one?
No, ma'am.
I'll appoint a public defender to represent you. Bonds are currently set at $5,000 on charges of resisting with violence and battery of a law enforcement officer. Those are both felonies punishable by up to 5 years in prison. And resisting an officer obstructing without violence is a misdemeanor punishable by up to 1 year in the county jail. It's $500 cash or surety bond. The state wish to be heard regarding those bonds?
You request they stay as set, Judge.
What would you like to tell me, Mr. Long? Not about the facts of the case, but about whether or not you would qualify for a lower bond.
Yes, ma'am. I was a veteran of 8 years, or I served for 8 years in the Air Force. I'm from the area. I'm more than willing to do volunteering service. I have no job at this time, but I'm a very able-bodied man. So if there's anything you could help me along those lines, I'm sure that would be able to help the community as well.
I'm showing no prior convictions, Ms. Harrell,
It does not appear so, Judge, but
except for no driver's license.
does indicate that he punched this deputy in the throat.
Yeah, it sounds pretty serious. I was reading it. It sounds like very serious charges.
Ma'am, I don't know what the report says, but okay. I can't really say facts, sorry. I have no history of violence. I didn't know I was acting violent. I was resisting, I understand that, but as far as pushing on him, leaning on him, no. That's not something I do.
All right. Based on the lack of a prior history, even though these are serious charges, I will address bond and reduce them somewhat. On the battery of a law enforcement officer, firefighter, I'll set the bond at $2,500 cash or surety. On the resisting with violence, I'll reduce it to $1,000 cash or surety. And resisting without, I'll leave it at $500 cash or surety.
Thank you, Your Honor.
Standard conditions, which are no violations of law. Make your court appearance.
Yes, ma'am.
No contact with the alleged victim, which
Yes,
is
Your
an
Honor.
officer. And set the arraignment for February 8th in Vieira with Judge Ingram, 8 o'clock in the morning.
Thank you, Your Honor.
And I appointed counsel. That's all. Are you Zechariah Bryson?
Yes, ma'am.
All right. Been arrested on charges of battery, criminal mischief, and failure to appear for docket sounding on those charges. The judge who had the cases set a bond of $1,500 cash or surety. Do you have a lawyer to represent you, sir?
Oh, no, I need a public defender. But may I say something real quick, Your Honor?
If you wish.
The failure to appear, I'm housed in medical right now, and that y'all can look it up. I was in severe surgery during my court date in Holmes Regional Hospital for intestinal surgery, and I still have a gaping wound in my stomach. That's why I don't have to.
Okay.
Like, that's valuable cause.
All right. Does the state have any information regarding that or any confirmation?
We do not, Judge. There's no indication that he attempted to contact the court or anything of that nature. We'd request the warrant amount.
Yes, I was in custody in the hospital.
He's saying he was in custody on January 10th, Judge. So that would be readily verifiable.
Pretrial release indicates that they confirmed he was not in custody.
Says he's in custody since January 13th. On January 10th, he was not in custody with the court.
Ma'am, I was arrested for having possession of a firearm as a felon, for discharge of a firearm as a felon, for burglary with a firearm as a felon, on like the 7th or 8th
I have
of January, and they took me straight from where they arrested me to the hospital because of me needing surgery. and I was in the hospital until 2-3 days ago when they brought me straight here from the hospital. And I went to first appearance for
Hang on a
those
second.
charges yesterday.
Okay, hang on, sir. So any other cases, but we definitely have one. 18 CF 11397. All right, on the other case, which is 18 CF 11397, I'm looking at the 923. It states date of offense 1718, date of arrest 1718. And then the clerk's records are showing the arrest on 112/18 because that's when he was actually brought in, apparently. Minutes of initial appearance. And on the minutes of the original appearance, it says arrest data 1718. Public defender was appointed. Set bonds, decreased various bond amounts. Doesn't address whether he, just, but it says first appearance, so. That would seem to confirm that he was in custody on January 10th. Let me see here. 252. 522.
Your Honor, that was case 18 CF 11397 you were just citing?
11397, yep, 18.
I'm showing initial appearance on January 13th.
Yep, but the initial appearance paperwork says the arrest date was January 7th. So it supports his comment that he's been in custody but in surgery. All right. While I don't have enough to dismiss the failure to appear, I do have enough to address setting the bond on the failure to appear at ROR. So he can address the dismissal of the failure to appear with the judge who's assigned the case if they can confirm that what he's telling us. So on the new charge, I'll authorize a ROR based on my review. It looks like you were in custody somehow, but you'll need to present paperwork for that so the Judge Ingram can.
I got all the hospital paperwork and
Fine, sir.
everything.
But I'm not dismissing the failure to appear. I'm just authorizing an ROR on those issues.
Okay.
But I've gone ahead and appointed the public defender for him. I believe I did that already. All right. So the court date on this new failure to appear is March 12th for dockets, March 15th for docket sounding because it's PD at 8 a.m. before Judge Ingram. That's all, sir.
Thank you.
He'll remain on whatever other charges.
Court TV is back, folks. May of 2019, we relaunch. We'll be on television. Gavel-to-gavel coverage of trials. If you love courtroom drama, this is the place to be.
Yeah, obviously.
Good morning, Your Honor.
Thomas Smith,
Yes, ma'am.
been arrested on charge of violation of injunction. Apparently, it was an injunction from Colorado. I reviewed the arrest form. I do find probable cause for the arrest. Do you have an attorney to represent you, sir?
No, ma'am.
Do you want one?
Yes, ma'am.
Can you afford to hire one?
No, ma'am.
I'll appoint a public defender to represent you. Do you live in Colorado, sir?
Yes, ma'am.
So your only ties here are that you were here on vacation?
Yes, ma'am.
And where are the children now, do you know?
They went home with my wife,
Okay.
and I have not been able to call and make sure they arrive safely. I've tried a couple times and haven't been able to get to a phone yet. But this is, I mean, not to speak of the facts, a couple things, Your Honor. I can prove this was a mistake. I have documentation that says I have custody of the kids 50-50, week on, week off, and it's been that way since this past May, and even before that I had them significantly. This was a mistake that should have got wiped off. It didn't. I understand that it's still there. I need to do something to get it wiped off. But, Your Honor, I didn't even know it existed. I truly didn't know. I was under the understanding that that protection order was wiped away in 2015, 2 years ago, 3 years ago almost.
So you have to address those issues.
Yes, ma'am. I'm just saying, I wanted you to know, Your Honor, that it really is a mistake.
All right. State want to be heard regarding a bond?
Judge, I'm a little concerned because this record shows a violation of a protective order involving domestic violence 3 times in 2013, and then harassment charges twice in 2013, bond condition violations twice in 2013, and then another violation of court order just in 2016. So there seems to be a history of noncompliance with court orders that's established by convictions. Judge, at this time, the state would request a $5,000 bond.
And, Your Honor, I'm a 6-tour combat veteran of the U.S. Marine Corps. I'm 100% disabled. A lot of those charges she stated were dismissed. I was found not guilty of. Some of them I was found guilty of the harassment. I've been in compliance with everything that I need to do. I've never not gone to court, Your Honor. I've never not taken care of anything. I've always done it. Not being from here makes it difficult for me to bond out. I would appreciate a personal recognizance bond or whatever you call it down here.
All right. I will set the bond at $3,000 cash as surety. Conditions are that you comply with whatever the Colorado courts require, and if the injunction is still active in Colorado, you need to comply with those orders until the Colorado court addresses it otherwise.
Yes, ma'am.
Based on the fact that you reside in Colorado and not in Brevard County, I'm not going to restrict you to remain in Brevard County, but your bondsman may have something to say about that if you're able to post a bond that's not a cash or surety bond, not a cash bond. If you post a surety bond, your bondsman may have some restrictions they want to place.
What's in a surety bond, Your Honor?
It's where you post some percentage, usually 10%.
Oh, I gotcha.
To promise that you'll appear. Set the arraignment for February 13th at 9 a.m. before Judge Brown in Vieira.
So I need to be back here February 13th?
If you do need to be here, I've appointed a public defender. If the public defender is in contact with you, directly in contact with you, and authorizes you for some reason not to appear, they're entitled to waive your appearance. But you can't do that without having confirmation that they're doing that, because if they don't have contact with you, they're going to tell the court, I don't have contact with them. And so the court's going to issue a bench warrant. Understand that?
Yes, ma'am.
Mr. Public Defender, is that an accurate reflection of what your office normally would do?
Yes, ma'am. It would depend on many factors, as you well know, the court itself, whether
Right.
it even be allowed. But yeah, that would be a good first step, is to inquire whether that's possible or not with counsel.
And I do know that if the public defender is involved on many occasions, they will cancel the court date and say you'll be notified if the state files an information. So, but I would suggest you keep in touch with the public defender so that you don't run the risk of having a bench warrant issued.
Yes, ma'am.
At this point, you're getting paperwork that will require that you appear for that arraignment at 9 a.m. before Judge Brown. And we have a good address for him? You have an address in Colorado, sir?
Yes, ma'am. It's 19632 East Progress Circle.
Okay. So that's where you'll be notified of any changes in the court date. That's where they keep in touch with you, sir.
Yes, ma'am.
All right, that's all. Pardon me? Oh, okay, so I need to put this here. Thank you. I thought I did, oh, no, I did Thomas. That was Thomas Smith, right? Adam Smith's next, okay, got it. Are you Zachary Birmingham?
Yes, ma'am.
Been arrested on charges of aggravated battery with a deadly weapon, a felony punishable by up to 15 years in prison. Do you have an attorney to represent you, sir?
No, ma'am.
You want one?
Yes.
Can you afford to hire one?
No, ma'am.
I'll appoint a public defender to represent you. I'll find probable cause for the arrest.
Ma'am?
Okay, I lost all of my, here. I gave him, I think it must have gotten stuck in your stack for some reason, sorry. Sorry. It was the whole stack of them, I mean, the whole.
Oh, I keep the other ones, just get them out of your way.
Okay, well, I don't have his. Birmingham's number 2 on the docket, thank you. So, the paperwork I have indicates that you're homeless. Do you have a place to live, sir?
Yes, I do. The alleged victim was my roommate, but my daughter's mother was with me when I got arrested, and said that I can live with her. Actually, I moved down to Florida a month ago to be with my daughter, and I watch her 3 days a week so her mother can go to work. So I asked that I can be released to continue to do that. I have no history of violence. I haven't been arrested in over 5 years. And I just asked that I please get a personal recognizance bond to, go watch my daughter and stay with her mother.
What's the state's position?
Your Honor, this appears to be a strong case involving stabbing, violence, unprovoked, and we'd ask that the bond remain at a minimum at $15,000.
Your Honor, if you can tell by my face that he attacked me, and I mean, I can't comment on the credibility of him and this witness. That'll be at trial, but I do have bruises and knots all over my head.
All right. I found probable cause for the arrest. I'll reduce the bond to $10,000 cash as surety. Conditions: no contact with the alleged victim or witness, and no return to the location. If you still have items of yours in that location, you may return one time with law enforcement to obtain your personal items. I'll set the arraignment date for February 8th at 8 a.m. with Judge Ingram. That's all, sir.
Thank you.
John Christensen,
Yes, ma'am.
been arrested on a charge of violation of probation. Do you have an attorney to represent you?
No, ma'am.
Do you want one?
Yes, please.
Can you afford to hire one?
No, ma'am.
I'll appoint a public defender to represent you. Bond is set at no bond, but I believe that, well, I don't know. Does he qualify for a bond? It's an on-site VOP.
Your Honor.
Yes, sir?
Yeah, I've got a job, and I pretty much completed about 9 months of probation successfully. I just made a mistake. Pretty much that's what led me here. So I just asked if there's any way you could set a bond or ROR.
I can probably set a bond, but I don't think on the ROR, sir. You've had prior violations and stuff where the court has given you various chances.
That's right.
I don't know what the court's going to be willing to do at this point in time. What's the state's position regarding an amount for a bond?
Sorry, Judge.
So essentially, the violation is based on consumption of alcohol and possession of alcohol in violation of the court's order, probation order.
And the probation was for neglect of a child.
Correct.
We suggest $15,000, Your Honor.
All right, I'll set the bond at $15,000 cash as surety. And set the court date with Judge Lemonitis on February 19th at 9 a.m. And I've appointed counsel for you, so you can talk with your counsel about trying to resolve things sooner. Are you Adam Smith?
Yes, Your Honor.
Been arrested on charges of DUI, charged as a fourth offense, so it's a felony, and refusing to submit to a breath test, which I believe is a misdemeanor. You have a right to have an attorney. Do you have one at this time?
No, Your Honor.
Do you want one?
Yes, Your Honor.
Can you afford to hire one?
No, Your Honor.
I'll appoint a public defender to represent you.
Your Honor.
Yes, sir?
I am self-employed. I've been a resident of Brevard for 34 years, and I do believe there's been an oversight on the charging. I do request a bond or an ROR, if all possible.
All right, there's also a charge of driving a license suspended or revoked.
That I do believe is,
I'm just telling you what the charges are.
I understand.
What's the state's position regarding a bond on the DUI? He has bonds of $2,000 on the driving a license suspended and $500 on the refusing to submit to the breath test.
Judge, based on all the circumstances and the fact this is a fourth or subsequent offense, we'd request at least $3,000 on the DUI charge.
You said three?
Yes, ma'am.
I'll set the bond at $3,000 cash as surety on the DUI. The other bonds will remain the same. Conditions of the bonds are no driving without a valid driver's license, and apparently you don't have a valid driver's license. If you thought you had one before, you don't now because of the new arrest. So no driving for any reason, and no consumption of any alcohol. That means not a sip of beer or wine. Do you understand, sir?
Yes, Your Honor.
If you violate those conditions, then the court will be inclined to hold you without bond. I'll set the arraignment with Judge Ingram at 8 o'clock in the morning on February 8th. That's all, sir. Are you Anthony Wagner?
Yes, ma'am.
All right. Could you back him up just a little bit so I can, so the mic picks him up? Thank you. I think that might be better.
Oh,
Mic's way up there, yes.
I was talking to the box.
We'll do the best we can, sir. You've been arrested on a violation, contempt order on a violation of a municipal ordinance. The arrest warrant says a $2,000 cash or surety bond or serve 10 days before your release. Do you have an attorney to represent you, sir?
Sorry?
Do you have an attorney to represent you?
No, I don't.
Do you want an attorney?
Yes, ma'am.
Can you afford to hire one?
No, ma'am, I cannot.
In municipal ordinances, they do qualify if they have jail time, correct? All right, I'll appoint a public defender to represent you. He's listed under,
Do I have a question about the bond?
I'm looking at it, sir.
I have 3 medical conditions that I see the health department over 3 times a week. I can't be in jail and make those appointments. They're scheduled that way just because that's what takes care of the lung problem and my kidney.
Well, the concern I have, sir, is that the judge who's familiar with your case set a status hearing for you to appear on various issues to give you an opportunity to address these issues, and you apparently failed to appear. And she set a bond of
I didn't fail to appear court, ma'am.
she's saying you failed to appear, sir. There's a court information that you failed to appear.
I wasn't able to do the farm time.
Well,
She sentenced me to.
all right.
And I called them and explained to them over, I said, leave a message. I left a message and a callback number, and they never got back to me.
All right.
What I'm asking for today, because of my medications that I need every day, between the Parkinson's and the gout and the COPD, which I already have, I have a lung infection, which the health department takes care of. I have to take this stuff 3 times a day.
Okay,
I can't get the medications in here.
What's the
I
state's
can't sit
position?
here
Excuse me,
days
sir,
on
wait a
an
moment.
RR bag.
Wait a moment, sir. Wait a moment.
Ma'am, I need an RR.
Wait a moment.
There's a state request the warrant amount and believes it's reasonable, especially given the 10-day option for release. And I'm sure that if the defendant raises his medical concerns with the jail, those will be addressed.
Okay. Ma'am?
Yes?
I beg you one more time, I'm sorry. Can I plead out to time served this morning? I've got to be out. I've got to have my medications.
I'm not sure that it's possible. Let me see. So there was a trial in this case a year ago. Order to serve 10 days at the work farm. No credit for time served. Report January 21st. Released at 5 p.m. to be released.
You went to trial on this?
So he has a sentence to serve. I can't take a plea. He's got the sentence to serve. If he serves the 10 days at the jail, then he'll be released.
Yes, Judge, I was unaware that he had gone to trial.
Yep, there was a trial. So, I sympathize with your situation, sir, but you have 10 days to serve at the jail. So you'll be released after 10 days if you don't bond. And a status hearing is set, order to show cause with Judge Neighborhouse on February 19th at 1:30. And if he serves his 10 days, then I guess the state can look at it and decide if they're satisfied at that point.
Yes, Your Honor.
All right? That's all, sir.
Just to be clear, though, he would still need to appear at that 2/19 date to answer the Judge Neighborhouse, even if he is released after
Yes,
the 10 days.
he still needs to show up. Judge Neighborhouse can choose whether or not to issue failure to appear and address it, but I'm not doing that. Nope. Can I use Zachary White?
Yes, ma'am.
The rest on 2 counts apparently of violation of probation. Maybe 3 cases. A new charge of driving license suspended or revoked, is that correct?
Yes. Mr. Christensen is my,
Right.
is my co-defendant. May I ask you a question?
Yes, sir.
I just started a job at Cracker Barrel, Titusville. I have no FTAs. I asked if you could please set a bond.
All right. You have a right to have an attorney to represent you. If you can't afford one, I'll appoint one for you. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No.
I'll appoint a public defender on all these charges. The state's position on the on-sites?
And it appears he was just placed on probation this month.
That's an error. I've been on since last year.
And the probation apparently is scheduled to run until 2021.
That's also incorrect.
Relatively quick violation on underlying felony charges. And there's a curfew violation as well as the new law violation.
Looks like he was reinstated to probation community control October 16th, according to it looks like a VOP was dismissed or it was reinstated.
Judge, the state will request $10,000.
All right, on the violation of probation for grand theft, I'll set the bond at $2,500 cash as surety. On the violation of probation for possession of burglary tools, I'll set the bond at $2,500 cash as surety. On the driving with license suspended or revoked, I'll set the bond at $500 cash as surety. All of those include a requirement, if you post bond, that you report to your probation officer within 24 hours of your release, or at least by the first business day of your release. I'll set on the driving license suspended or revoked, we set before Judge Baker for docket sounding on March 15th at 9 a.m. And the violation of hearings or arraignments will be February 19th at 9 a.m. with Judge Lemonitis. That's all, sir.
Okay, what was the total on that?
Add them up, I think it's $5,500. Actually, you can give me back the other ones. That was the take-ahead list, I believe. What was your name, sir?
Jacob Babcock.
You're charged with retail theft,
Yes, Your Honor.
misdemeanor, punishable by up to 60 days in jail if it's a first offense, or a year in the county jail if it's a subsequent offense. Hang on, sir, I need to clear out some stuff off my computer.
Yes, sir. Or yes, Your Honor.
I let it get too big and then I can't see everything. It won't let me open things. It's really a pain. And I got to close everything individually. There should be a way to close everything all at once, but I haven't figured that one out yet. Right, and then you have to wait for it to boot back up again, right. The joys of electronic files. him. I'll find probable cause for the arrest.
Your Honor, I was completely cooperative and I was very wrong, but I was just released and they actually closed down the Salvation Army, their store which had closed. I have a job interview coming up tomorrow, and I honestly have no way to postpone. I was just released from here doing a 6-month county sentence. And as if it was up to the corporal, he would have let me just get another court date, but they couldn't do that because of the store's situation. Or I guess it's they have to press charges or whatever. But other than that, I mean, the case is closed. It was I was wrong, I'm sorry, and please, can you give me a chance to be released? I have no way of getting out, and I just needed something to wear.
So are you on probation?
No, ma'am.
So when you finished your other cases, it was a release all the way?
EOS all the way. I'm not on probation at all. I'm very sorry.
Does the state have priors of petty theft or retail theft on him?
Judge, show 8 juvenile charges, and then after that, burglary, occupied dwelling in 2012, several other drug and resisting charges, trespass, all the way through 2017, where he had a burglary conviction, as well as petty theft convictions in 2015 and 2016. So Mr. Babcock does not appear to be learning from his mistakes. And the state will note that these are not thefts of necessity. One of the items stolen was a pair of sunglasses.
I'm sorry. I'm sorry. I just needed socks and a pair of pants and shirts. I have a job interview here tomorrow, and I mean, if I could handle it, I would handle it now.
The problem is if you handle it today, sir, and I took a plea, it probably involved jail time, so that's not going to help you out.
Right.
I think it's better just to go ahead and set you down for whatever needs to be done. I've appointed the public defender. I don't have a problem with reducing the bond, but there will be some bond that you have to post.
Could I please be released? I have no way to post a bond. I have a job that I start literally tomorrow. And that's the only reason this happened, and I'm very sorry. The officer could tell you that I was very cooperative, and he did not, and he tried every which way to make it where I didn't come here today, but I was wrong.
What's the state's position regarding
please.
like a community supervision release or something?
We would object, Judge. I mean, he just has so many convictions and relatively recent ones, and has had so many opportunities to make different choices.
Please.
We'd request just to schedule him out.
Please. If I'll do any kind of release on, please, give me a chance. Please give me a chance, Lord. Just give me a chance. Please give me a chance.
I'll reduce the bond to $500 cash or surety. Conditions: no return to the bells, no violations of law. Make your court appearance.
Your Honor.
And set the matter for docket sounding before Judge Baker, I believe, in Titusville on March 15th.
Your Honor.
I've heard your pleas, sir. I've listened to the state. I've looked at your record. I'm probably going beyond what I should by reducing your bond as much as I have. That's all I can do for you. That's all, sir.
Hey, folks, if you love drama inside the courtroom, get ready for May of 2019. Court TV is back. We'll be on the air with gavel-to-gavel live trial coverage of the biggest cases in the nation.
Your name, please?
Charmaine Brady.
You don't have to stand up. It'll catch you as long as you're within about a foot of it. You're fine.
All right, Charmaine Brady.
Thank you, ma'am. Don't want you to have to stretch yourself too much. All right, you're charged with driving under the influence, driving under the influence of property damage. Do you have an attorney to represent you?
No, I do not.
Do you want one?
Yes, I do.
Can you afford to hire one?
No, I cannot.
I'll appoint a public defender to represent you. Looks like prior conviction for DUI back in 2014, some prior arrests. What's the state's position regarding a bond?
Both the prior and the current one involve property damage or personal injury. They would request $2,000 as to the property damage count and $1,000 as to the regular DUI.
Well, the bonds are currently set at $1,000 on the driving under the influence and $500 on the DUI with property damage. I don't know why that one is less. I think they
That is
both.
1,000 on my 923, Judge.
They're just.
There was a bond correction done, 500 per the bond schedule.
Oh.
DUI on count one, the reason it's at 1,000 is they indicate that it's her second offense.
Right. I'm going to set the bond on both at $1,000 cash or surety each. Ms. Brady, the requirement of this bond is that you not consume any alcoholic beverages whatsoever. That means not even a sip of beer or wine. Also, you're required not to drive a motor vehicle unless you have a valid license, and you probably will not qualify for a valid license for several months. Do you understand that, ma'am?
I do.
Your next court date is an arraignment with Judge Ingram in Vieira on February 8th at 8 a.m. That's what it says. Is there a different date because of the DUI?
Yes, for some reason, this mistakenly was assigned to Judge Dugan, and it's clearly a misdemeanor. Give me just a moment, and I'll have it.
Ms. Brady, it might be a different court date, so I just want to make sure we give you the right court date, so you're not confused. Trying to make sure we give you the right court date.
Okay. It'll be a traffic arraignment February the 12th at 9 a.m. in Vieira with Judge Farrell Goslow.
All right, so you have a different court date, but make sure you'll get it in writing.
I'll get it in writing.
You'll get it in writing, February 12th.
February 12th.
Yes, sir. Yes, ma'am.
At what time?
I think 9 a.m., but they'll give that to you in writing.
Okay, thanks.
Okay, my pen ran out of my personal pen that I brought with me, so there's one here. Does that work?
Sure.
Okay. All right, thank you. Yeah, it looks like it works. Since it's a paperless courtroom, of course I need a pen, right? Are you Daniel Brown?
Yes, ma'am.
Charged with a violation of probation You're also charged with new offenses of possession of controlled substance without prescription, 3 counts, use or possession of drug paraphernalia, and resisting an officer without violence. The possession charges of controlled substance, I believe, are third-degree felonies punishable by up to 5 years in prison. Use or possession of drug paraphernalia is a misdemeanor, as is resisting without violence. Both of those are first-degree misdemeanors punishable by up to 1 year in the county jail. And your on-site violation is on an underlying offense of battery, which is a first-degree misdemeanor. Do you have an attorney to represent you, sir?
If I can get, because I have a job, I'm the only one supporting my family too, and I basically no show this morning, but if I can get out today, I'm sure they'll keep me on. I'm a service tech for Market Refrigeration, and I can't afford one. Yes, I got money set aside, but it just depends what my bond is at, and there's certain issues to the case I don't really want to discuss, but
All right.
if I can get my bond.
Hang on just a minute, sir.
I do want to state, when you get a chance, let me know.
Do you find probable cause for the arrest? What's the state's position regarding bonds?
That's what I wanted to say. That wasn't.
Sir, I'm asking the state for input first. I'll ask you some questions in a minute. Go ahead, Ms. Harrell.
On the VOP, Your Honor, we would request $5,000 on the controlled substance, $2,000, and on the possession of use drug paraphernalia, $500.
All right. Mr. Brown, I can't go into the facts of your case at this point. We're not here on an adversary hearing, but I will address your request for a bond, and if you want, whatever you want to tell me.
Is there any way I can get it reduced just a little bit so I can bond out myself today? I have no FTAs. I've been complying with getting everything done. I was actually about to be off probation next month because they were gonna let me early term as long as I got everything done. I've been completing all my requirements. I've done all my classes that they required me to do. I have 2 more weeks, which is tomorrow. If I have to, they'll make me start everything over if I don't show up for class tomorrow too. But I've been making all my classes, doing everything. They send you homework that you have to get done to stay in the class. I mean, I've been doing all my requirements, checking in and all that.
All right.
So,
all right, sir, I'm ready to rule.
If I could just get it down a little bit.
I said I'm ready to rule. On the battery, the violation of probation, I'll set the bond at $1,000 cash as surety. On each of the charges of possession of controlled substance, I'll set the bond at $1,000 cash as surety. And on the use or possession of drug paraphernalia and resisting an officer, I'll set the bonds at $500 each. So your total bond is $5,000. I'll set the violation case for an arraignment on February 2nd at 9:15 with, it says WD. So is that a reduction from a felony? Is that what it was? Is that why it's still listed as a felony? Okay, that must be, even though it's, okay, got it. And then on the new cases, it'll be arraignment February 8th at 8 a.m. with Judge Ingram.
Okay.
And he says he's going to retain counsel. If by the time of his arraignment he hasn't done so, then he can apply for public defender at that time.
Okay, so I will have another chance to apply for a public defender.
If you haven't been able to bond out or you haven't been able to afford to get one, yes, sir, you can reapply at that. You can apply at the time of your arraignments.
Okay.
That's all, sir. Are you Jonathan Brown?
Yes, ma'am.
Charged with failing to appear for an arraignment on an underlying charge of driving a license suspended or revoked. This is a felony based on the fact that it was a third offense. Bond was scheduled, set for $4,000 on the failure to appear warrant. Do you have attorney to represent you in this matter?
No, ma'am.
Do you want one?
Yes, ma'am.
Can you afford to hire one?
No, ma'am.
I'll appoint a public defender to represent you. I'll leave the bond set at $4,000 cash as surety, set it for early resolution arraignment or addressing on February 8th at 8 a.m. with Judge Ingram. So they do early resolution and arraignments in the same day? Yeah. Okay. That's all, sir. Take care of Mr. Bryson. Him. Are you Vera Dillard?
Yes, ma'am.
You're charged with, let's see, introducing contraband into a jail facility.
Yes, ma'am.
I'll find probable cause for the arrest. Do you have an attorney to represent you?
No, ma'am.
You want one?
Yes, ma'am.
Can you afford to hire one?
No, ma'am.
I'll appoint a public defender to represent you. Bond is set at $5,000 cash as surety. State wish to be heard.
No, Judge, we like that amount. I'm sorry. You're asking, if we do support the $5,000. I thought you had already ruled.
Nope. I'll leave the bond set at $5,000 cash as surety. Set the matter for an arraignment February 20th at 8 a.m. in Titusville before Judge Baker. That's all, ma'am.
And Your Honor, skipping over Carlos Durantes for Spanish brings us to Taekwondo English.
Yes, thank you. All right. State your name, please.
Taekwondo English.
Charged with not having a driver's license, which is a misdemeanor. Bond is set at $500 cash as surety. And possession of controlled substance, a violation of probation on an underlying offense of possession of controlled substance. Bond is currently set at none, but then it has 5,000 in parentheses. Why is that? Okay. Thank you. Do you have an attorney to represent you, sir?
No, ma'am.
You want one?
Yes, ma'am.
Can you afford to hire one?
No, ma'am.
Did you complete an affidavit?
You bring home any money, any income?
No.
No, you don't have any funds or anything?
Mm-mm.
No. Total amount of debt, you have to guess.
Did it?
Yeah. Do you owe anybody any money?
Mm-mm.
No. Do you have temporary assistance or SSI?
Mm-mm.
Were you out of jail on bond?
Mm-mm.
No.
Is everything on the affidavit true and correct?
Yes, ma'am.
I'll appoint a public defender to represent you. Does the state have any objection to the $5,000 bond on the warrant?
No, ma'am.
I'll reinstate the $5,000 on the warrant on the violation of probation. And the no driver's license, I'll leave that $500 cash as surety. The no DL is set for a traffic arraignment February 13th at 1:30 in Melbourne with Judge Ingram. And violation of probation is set for arraignment February 26th at 9 a.m. before Judge McKibben. Is that correct? KM?
Yes.
Thank you. That's all. Anthony Flagg?
Yes, ma'am.
Charged with failing to appear for a plea or early resolution for charges of possession of cocaine with intent to sell or deliver, possession of less than 20 grams of cannabis, possession of drug paraphernalia. You have an attorney to represent you?
I was in the process of hiring another attorney.
Do you wish to have me consider appointing counsel for you today, or are you planning to hire your own counsel?
I have my own counsel. I will have one. Would I be having a bond?
Well, your bond is currently set at no bond. I need to look at the warrant and see what it says.
The warrant requests no bond, Judge. Judge Dugan wants to see him.
Well, how would I be able to see him if I wasn't here?
Well,
Well, I've been applying to all of my other court cases. I just had a death in my family, and I wasn't able, no one notified me, and I was in the middle of hiring another attorney. And I had a public defender, and I spoke with her, and I told her, I told her my issues, and she was saying she was gonna let it prolong it, and so she never. I was trying to get in contact with her, but I never could get back in contact with her. But my bail bondsman was saying they would keep my case. I've been to court.
They've actually surrendered you on that bond.
Yep.
Ma'am,
They're not staying on the bond.
I can't hear you.
Your bondsman won't stay on the bond. They've already surrendered the bond.
Yeah, but they told me they would be able to work with me. And I just spoke with them.
I will double the bond from $5,000, which was the original one that was forfeited, to $10,000 cash as surety. I'll set the matter for early resolution on February 8th at 8:30, since you said you're going to obtain counsel. And do I need to set aside the previous bond and release it for the record? Because they surrendered him, correct? All right, I'll go ahead and do that. And if you want to have your bond reduced further, you need to apply to Judge Dugan. I believe it's his case. Otherwise, you'll be transported for your court date on February 8th.
So I will have to stay. I don't have a bond today.
I'm giving you a bond, sir, $10,000 cash
Okay.
surety. If you
All
can
right.
post that, you can post that with the same conditions previously ordered.
Yes, ma'am.
That's all.
Alrighty.
Are you John Francis?
Yes, ma'am. Ma'am, can I have a moment with my attorney?
Yes, sir. Deputy,
Ma'am?
can you tell me when we get to the group that came in after my colloquy?
Absolutely.
Thank you. Appreciate it.
Your Honor,
Yes?
I'm trying to,
Oh, you want to plea on to
I want to try to see if I can plea out today to probation.
So you're charged with retail theft, less than $300, resisting arrest without violence, use or possession of drug paraphernalia, giving false name or identification to LEO.
Yes, ma'am.
I can't promise you probation, sir. These are all charges that could put you in jail for up to a year on each count. I can ask the state if they want to make a plea offer, but I don't know if that's something that they're prepared to do.
Your Honor, we're not prepared to do that today. There are pending other charges that this gentleman has, as well as a very lengthy criminal history involving felonies.
Sir, do you have an attorney to represent you?
No, ma'am.
Do you want one?
Yes, ma'am.
Can you afford to hire one?
No, ma'am.
I'll appoint a public defender to represent you. The bonds are quite reasonable based on the charges and the record. I'll leave the bond set at $500 on each count. set the matter for arraignment before Judge Brown on February 13th.
Yes, ma'am.
Looks like you have other court dates pending on other cases.
Yes, ma'am.
So you have several court dates. You need to keep them straight and make sure you appear on all of them.
Yes, ma'am.
If you don't bond out, then you should be transported for your court dates.
Okay.
All right, that's all, sir.
Thank you.
And I found probable cause for the arrest.
Good afternoon.
Your Honor, are you addressing Harding next?
Let me see.
That's me, yes.
Yes.
And just so the court is aware, this is the case that relates to the juvenile the court met earlier.
Yeah, he had a warrant, I guess.
And I do have a note that the juvenile's mother is requesting electronic monitoring if there is release.
Okay.
Yes, I have, my parents live on Satellite Beach. That's where I'm going. If you look at the past, we've been together 17 years. It's now a routine for her to remove me by calling, and I did nothing wrong. So, but anyway, that's facts.
Let me read your arrest form.
Yes,
so
ma'am.
I'll determine if there's probable cause. Hang on.
It's all hearsay. It's all right. Not looking good? Oh, I just looked at your...
I'll find probable cause for the arrest. You have someplace to live other than with your
Absolutely.
wife and stepson?
Well, I have a biological son with her as well.
Okay.
And then Tyler Sorrentino I've been taking care of since he was 2.
All right.
So
but
he
you
is
have-
my son.
You have someplace to live other than with
My
them?
folks, yes, in
Okay.
Satellite. I'm done with her.
All right. What's the state's position regarding?
Pre-trial release or anything like that would be great.
Excuse me, sir, I'm talking to the
No,
state.
no, I got you. Yes, ma'am.
Just there is some criminal history. The state would request $1,000 cash surety for each charge, each count.
Do you have an attorney to represent you, sir?
No, ma'am.
Do you want one?
Yes, please.
Can you afford to hire one?
No, ma'am.
I'll go ahead and appoint a public defender to represent you.
Judge, I don't recall, was Tyler appointed the public defender this morning?
He's still in custody.
I don't recall.
She didn't come get him.
That's right, it was on the old petty theft. It was an old petty, yes. No, I did not appoint the public defender.
Okay.
So that shouldn't cause a conflict. Do we still have the sentinel monitoring? He would qualify for that as an indigent, correct? I'm sorry, Ms. Harold, did you have information about what the alleged victim was asking for?
Just that there was electronic monitoring if there was release.
Okay. All right.
Which there was last time.
I'm showing some traffic offenses in the last year, but all the other records seems to be pretty old.
Yes, ma'am. Very old. And yeah, I will have no contact with her. This is just ridiculous.
So, state have any objection to a release either on ROR or community supervision with electronic monitoring?
Thank you. GPS.
Sir, I haven't done it yet.
Well, Judge, we would stand by a request for $1,000 cash cert in each count, and then if he's able to bond out, we would request electronic monitoring.
Well, the GPS will watch me.
What are the requirements of the electronic monitoring program in terms of release conditions other than the no contact?
No contact, no return to the victim's residence.
Do they do?
Or employment within 1,000 feet.
Do they do? Doesn't matter if it's a bond or ROR or community supervision. That doesn't make any difference.
That makes no difference whatsoever. Any other conditions you want to impose?
Okay.
If they're monitoring his whereabouts as far as him coming within 1,000 feet.
All right. So I'll set a bond on each count, $500 cash or surety, and order as a consequence of the minimal bond that, as well, that there be electronic monitoring through the Sentinel program. That means and you're not to have contact with the alleged victims, either the wife or the stepson. You're not to go within 1,000 feet of their residence. You may go one time with law enforcement only to obtain your personal possessions, such as, a few clothes and a few items of personal possessions. You don't get to take anything out of the house.
I would not do that. Yeah.
All right, and your employment shouldn't bring you within 1,000 feet of the house, and you should not go within 1,000 feet of your wife's employment if she's employed.
She is not.
Do you have any questions about those requirements, sir?
Absolutely not.
Judge, we would also request if the child is in school, that he not go to the child's school either.
Well, that's the problem. He's not. Check in with that. I'm not trying to tell
Well,
him.
but if he's supposed to be going to school,
Yeah,
then
well,
you shouldn't be going to the school that he's at,
of course not.
right? That's all they're asking for.
Yes, ma'am.
And if he's employed, you're not to go within 1,000 feet of his employment location.
Yes, ma'am.
Obviously, you'd have to know what that was, but you're sort of tasked with knowing those things if there's an issue. All right.
So he's still in custody, my son?
No, he's not.
Okay, good.
He was released.
That's good. Feel bad for him.
I'll set the arraignment for Judge Ingram in Melbourne on February 13th. Anything further requests from the state?
No, Your Honor.
Did I include all the conditions you need for sentinel monitoring? And they'll explain that to you. It requires that you keep it charged, that you report whatever they need to report and keep them advised where you are.
I've
those
had
kinds
it.
of things.
Yeah.
All right, that's all, sir.
Thank you. Thank you, State.
Your name, sir?
Theophilus Jordan.
You're before the court charged with grand theft, an on-site violation of probation on an underlying offense of grand theft and dealing in stolen property. And it looks like on-site for underlying offenses of fraud and grand theft. On-site on grand theft and organized fraud. And a new charge of driving a license suspended or revoked. Do you have an attorney to represent you, sir?
No, ma'am, I do not.
Do you want one?
Yes.
Can you afford to hire one?
No, ma'am, not at the time.
I'll appoint a public defender to represent you.
Yes, ma'am.
I'm behind on the signing here, aren't I? State's position regarding bonds?
There's not a warrant in on that?
Nope, they were on site for the new arrest of driving license suspended.
We would request $2,000.
On the VOPs, how do we do that? Do we have to put it per count or just on the VOP?
It would just be on the on-site charge.
Okay.
Okay,
Are you asking for that on each case?
Yes, ma'am.
am I able to speak on the bond amount now, ma'am?
Yes, what would you like to tell me, sir?
Okay, yes, I actually have two jobs, two part-time jobs and a full-time job watching my son. My wife is in nursing program at Kaiser College, and anybody familiar with that, it is a very rigorous program, and I need to be there to watch him. Luckily, today was a holiday, so she didn't have to go. I'm the only source of income right now, and I would ask that I can get the bond amount reduced as much as possible because we are pretty much own a fixed income. I don't make that much as it is. And I've been on probation for over a year, and I've complied with everything so far, and with no hiccups, but this happened to be the hiccup. And ever since my last arrest, when I got out and got on probation, you know, I finally got things back on track with my family and my wife, and we're on good terms right now, so just want to continue down a good path. And one more thing, since being here at 1:30 in the morning, I am sleeping on my steel bunk bed. They did not give me a mat because they said they were out. And so I've been sleeping on a cold metal bunk bed without a mat. So,
Unfortunate.
yeah, I understand.
The state will modify its request down to $1,000 bond rather than $2,000.
I was prepared to do $1,000 on each charge of violation of probation. So that would be a total of $3,000, I think. And then on the driving license suspended revoked, I'll set at $500 cash surety. Set the violation hearing matters for arraignment before Judge Maloney on February 14th at 8:30, and set the traffic arraignment before Judge Garagos and Vieira at February 12th at 9 a.m. If you are in custody, they'll transport you. If you're able to bond out, sir, then you'll need to make those court appearances.
Yes, ma'am. Thank you.
That's all. Oh, report to your probation officer within 24 hours of your release.
Deborah Lonergan, surety bonded. Skipping over Jonathan Manuel for Spanish translation brings us to William Marshall.
Charged with driving under the influence and also an infraction. Do you have an attorney to represent you, sir?
No.
Do you want one?
Yes.
Can you afford to hire one?
No.
I'll appoint a public defender to represent you. Where do you live, sir?
1866 Hazleton,
How long have you lived in Brevard County?
since I was 5.
And are you working?
Not at the moment.
Going to school?
No, I was actually thinking of going for massage therapy, though.
And do you have family here?
Yes.
Are you going to be able to post your bond? It's currently set at $500.
I can see if somebody can, but if you could RR, that'd be wonderful.
What's the state's position?
There's a state's concern because there's an allegation of drug influence, and Mr. Marshall has a heroin conviction just from 2017. We request a $1,000 bond amount on the DUI.
Looks like a prior DUI in 2008 was reduced to reckless.
Yes.
Recent charge of possession of heroin and possession of paraphernalia.
Those appear to be convictions.
Are you on probation, sir?
No.
I'll leave the bond set at $500 cash as surety. Conditions are no driving without a driver's license or beyond the restrictions if you're granted a restricted license, and you're not to consume any alcohol or use of any illegal drugs. That means nothing, either a sip of beer or wine, and don't be hanging around people that are smoking marijuana and claim that you're not smoking it, because if you're showing up with drugs, you're going to be violating. Do you understand that, sir?
Okay.
Next court date is February 12th with Judge Garagosa in Vieira, I believe. Is that correct? At 9 o'clock? Anything further from the state or the defense?
No, Your Honor.
That's all.
I have a question on here. It says you can drive for 10 days with this paper if you're like going to work and whatnot.
So that's between you and the Department of Highway Motor.
Okay.
That's if they say that that's a valid restricted license for a few days, then you can address that with them. But I'm just saying you can't drive beyond any restrictions or without a license.
Okay.
All right. Are you Tracy Meerheim?
Yeah.
Before the court charged with aggravated battery and domestic violence. Do you have a lawyer to represent you?
No.
Do you want one?
Yes.
Can you afford to hire one?
No.
I'll appoint a public defender to represent you.
Okay. Thank you.
Ms. Harrell, have you read the arrest form?
I have.
Do you want to be heard regarding probable cause?
Judge, given the, well,
It's probably there's actual probable cause, but it's sort of shaky on the ground. I mean,
I understand the court's view on that. I'd have to defer to the deputy who was on scene, who made a determination based on demeanor and
she
other
was the
things,
primary.
but I understand where the court's coming from.
Ms. Miriam, do you and the alleged victim reside together?
Not anymore.
So you have a place to live that's not in his home, or the home he's not in your home,
Yes, ma'am.
and you don't have any reason to have contact with him?
Not at all.
I will find probable cause, but I'm going to treat it more like a misdemeanor rather than a felony and set a bond accordingly. Does the state want to be heard regarding an amount of a bond?
Ma'am, can I ask you? I've never been in trouble before.
Okay, I'll address that, ma'am.
Judge, we would just ask for the schedule amount.
What about community supervision? Would that not be appropriate?
I'm not able to agree to that, Your Honor, but we'll have to leave it at the
Will
schedule
community
amount for
supervision
the.
accept one that's a felony? Okay. Okay. All right.
They just can't release prior to court.
Okay.
without-
Ms. Meerheim, where do you live now?
With my mom
Okay, and how long have you lived in Brevard County?
all my life.
Have you ever failed to appear in court?
I've never had to go to court.
Never arrested before?
I've never been in trouble. That's what I'm saying. This is self-defense that went somewhere else.
I can either set a bond of 500 cash as surety, or I can release you on community supervision, which is like a pretrial probation, and there's a fee involved that you have to pay on a regular basis. I think it's, what, $10 a week? And you have to check in once a week and follow their instructions. But that way you don't have to post anything initially. I'm giving you the choice whether you want to be bonded with just conditions without having to report, or if you want to be able to get out without having to post a bond, but be required to be under the supervision.
So it's either I get out without a bond and have to go to probation, or I have a bond.
That's essentially correct. If you want to talk to the attorney about it, you can.
That's exactly right. You just nailed it on the head. It's like probation. So if you can make the $500, it's better.
Yeah, let me just go ahead and bond now.
You want to just do the bond?
Mm-hmm.
All right. I'll set the bond at 500 cash as surety. Order that there be no contact with the alleged victim, no return to the residence except one time with law enforcement to obtain your personal items if you have items at the same residence. And set your court date for February 8th at 8 a.m. in Vieira with Judge Ingram. That's all, ma'am. I did your public defender, correct?
All right, skipping Allegra Nieves for Spanish brings us to Andrew Pollock.
All right, your name is, sir?
Andrew Pollock.
We're arrested on a charge of retail theft from a merchant, a second offense. It's charged, your bond is currently set at $500 cash as surety. This is a misdemeanor, published, punishment by up to 1 year in the county jail. You have an attorney to represent you, sir?
No, ma'am.
Do you want one?
Yes, ma'am.
Can you afford to hire one?
Unfortunately, no.
I'll appoint a public defender to represent you. I'll find probable cause for the arrest. Where do you live, Mr. Pollock?
Ma'am, I've been renting for the last year over in Northwest Palm Bay. I'm still employed. I've been off for, I would say, about the last month in between projects. I remodel homes for a family friend of mine. I start back to work this week.
It says there's a possible outstanding warrant for a failure to appear from out of state from 2015.
Yeah, it's a DUI from, I believe, Iowa, but it's over 8 years old now. I just never returned back to the state.
Now, it says the warrant is from 2015, so
Yes,
maybe
ma'am.
the charge is that old, but the warrant
Right.
is not that old.
It's from the DUI that started in 2009 or 2010, I want to say. But I went back there. I served maybe 2 months for it, and they let me out on some kind of a conditional release, I believe it was, with the conditions of community service. But I ended up having to come back to Florida regardless, and they reissued the warrant on it.
All right. I'll leave your bond set at $500 cash as surety. Set the matter for looks like an arraignment with Judge Brown and Vieira on February 13th. I got that right? Okay.
There's no possibility of ROR on that. at
No,
all.
sir. And no return to the Walmart.
Okay.
State have any other requests?
No, ma'am.
All right, that's all, sir.
Thank you, ma'am.
William Paz?
Yes, indeed, ma'am.
Been arrested on a warrant for something regarding non-support. Let me pull up your case. I'll address it. Alleges that on October 30th, you failed to appear before the hearing officer. The judge assigned the case, issued a warrant for you to appear with a purge amount of $1,000. Are you going to be able to Pay the purge, sir?
The last time I was here, I had Silverman had told me to go back to the court in Melbourne. I went in there. I had explained to them that I was homeless to start taking the money out of my check. I still have my job.
All right.
This was not done. I mean, and being that I don't have a address, I can't get no type of paperwork.
All right. Well, I guess you can address that with the hearing officer. Is it the day after tomorrow? So on Wednesday at 1 p.m. Your non-support bond is remaining at $1,000. You can either, even if you post the bond, you still need to show up for the court date. If you don't post the bond, they'll transfer you for the court date on January 17th at 1 p.m. before Hearing Officer Perez in Melbourne. That's all, sir. Where do you need me to sign this? Thank you.
Your Honor, the rest of the males from this point forward were not present. I have them all standing for you.
Thank you. Gentlemen, I'm Judge Rainwater. You've been here watching me for a while, but I'll need to advise you of some of your rights and some things that were happening today. The purpose of today's hearing is to advise you of the charges against you, to address your bond, to determine if it's raised or lowered or remain the same, and to appoint counsel if necessary and advise you of some of your rights. You have a right to remain silent. Anything that you say today can be used against you at a later hearing or at the trial of your case. We are being recorded today, so anything you say is available to the state for prosecution purposes. You have a right to have an attorney to represent you, and if you cannot afford to hire an attorney, I will appoint one for you. In order for me to do so, I just need you to enter swear under oath that the facts that you've included in your affidavit are true and correct. So please raise your right hands. Please raise your right hand, sir. Do you each swear or affirm that you'll tell me the truth, the whole truth, and nothing but the truth? Thank you. Go ahead and have a seat. I don't think I put everybody else under oath at the beginning. I don't know. Philip Robinson?
Yes, ma'am.
For the court charged with domestic battery by strangulation. It's a charged as a felony. Do you have an attorney to represent you?
No, ma'am.
Do you want one?
Yes, ma'am.
Can you afford to hire one?
No, ma'am.
I'll appoint a public defender to represent you. I'll find probable cause for the arrest. You have a place to live that's not with the alleged victim?
No, ma'am.
I'm sorry, was that a no?
No, ma'am.
All right. Looks like do you reside in Brevard County or elsewhere?
I have lived in Brevard County before.
But your current address is in Wisconsin? Or not?
It was. I came down here from there.
Okay.
Came back down here from there.
Looks like you're awaiting extradition to Wisconsin.
Yes, ma'am.
I'm just curious why. Looks like he was arrested on January 13th. Today's the 15th. No, it looks like the offense was on January 13th. He was arrested on the 14th. Today's the 15th. Okay.
I was brought in on the 13th, very early in the morning. I've been in the jail since about 3:30 a.m. on the 13th.
All right. And you've been told that you have a warrant, and they're holding you for the warrant from Wisconsin?
Just waiting for them to come get me.
Well, they won't come get you until you resolve the current local charges, I don't believe.
Give me some time for the weather to warm up. It's a long, cold ride.
All right. So, state's position regarding a bond in this case?
We can go with no bond, ma'am. That's cool.
You're okay with no bond?
No, I'm cool with that.
All right. We'll leave it at no bond then.
I'll let the state take a break. She looks like she's getting aggravated.
She's not aggravated. She's just telling me what I need to know. I'll set your arraignment for February 8th at 8 a.m. before Judge Ingram in Vieira. And I don't believe that they'll transport him or extradite him until the local charges are resolved.
I believe you're correct.
So, and I pointed a PD for him, didn't I? Okay, so you can talk with your lawyer about how to resolve this matter.
Wonderful, thank you.
That's all.
All right,
Oh,
skipping
yeah,
David.
well, he's got a no bond. Oh, no contact, no emails, no letters, no phone calls to the alleged victim, no contact on social media or anything else that you might have access to. Don't make calls to her.
All right, skipping over David Salinas for interpretation. Thomas Shemp, surety bonded. Next up, Patricia Stevenson.
Okay, I didn't get very lucky on the numbers today. Especially with a lot of interpreters. All right, are you Patricia Stevenson?
Yes, ma'am.
You're charged with a violation of injunction for protection for under domestic violence. Do you have an attorney to represent you?
No, I do not.
This is a misdemeanor punishable by up to 1 year in the county jail.
May I speak?
In just a moment, ma'am. Do you have an attorney?
No, ma'am.
Do you want one?
Yes, please.
Can you afford to hire one?
No, ma'am.
I'll appoint a public defender to represent you. I will find probable cause for the arrest.
Ma'am?
Bond is currently set at no bond. Does the state wish to be heard regarding the bond?
Judge would request $2,000.
All right, Ms. Stevenson, you wish to be heard regarding the bond?
That's kind of high. I don't know why we have a bond. This message was sent when we were in the same house together before there was an injunction even in place.
It's not how it's stated in the,
And in the message it says about us going to Walmart together, and we haven't lived together for over a month.
I understand that, ma'am, but it,
I think her point, Judge, is that it all seems quite petty.
well, I don't agree, I agree that it's, but still, the allegations are these text messages occurred after an injunction was put in place, approximately 2 or 3 weeks earlier.
That's incorrect, ma'am, and I can prove that.
Well, that's an issue for a trial or some other further hearing. The allegations include that the text messages were received on that date. The officer said he looked at the phone and that it was sent from your phone at 19:35 hours to Gregory's.
It was sent at that time, just not that date, not today, or even yesterday, ma'am. Like, my husband and I are we're getting a divorce, and it's...
Well, all I'm saying is I've read the arrest form, ma'am. Okay. That's what it's alleging. So,
Can I have a ROR or a pretrial release?
I'll set the bond at $500 cash or surety. conditions are comply with the injunction, and no contact with the alleged victim. Arraignment date set February 13th at 9 a.m. with Judge Ingram in Melbourne. That's all I have. Are you Christopher Pope?
Toppy, yes, ma'am.
Looks like there's 7 cases. Violation of probation, 1, 2, 3, 4, 5, 6. 6 violations of probation on underlying offense of arson, and then a new charge of battery. Do you have an attorney to represent you, sir?
No, ma'am.
Do you want one?
Yes, ma'am.
Can you afford to hire one?
No, ma'am.
I'll appoint a public defender to represent you. Looks like the felony violations are from charges in 2007.
Yes, ma'am.
Find probable cause for the arrest for battery. So the violations of probation stem from the new arrest. Do you have an attorney, sir?
No, ma'am.
Do you want one?
Yes, ma'am.
Can you afford to hire one?
No, ma'am.
I'll appoint a public defender to represent you. On the battery charge, I would set a bond of $1,000 cash as surety, no contact with the alleged victim, and no return to the location. I believe it was a business, bar or a tavern.
Yes, ma'am.
And on the violations of probation, what's the state's position regarding those violations?
This is just an on-site, Judge, there's no warrant.
That's correct, it was based on the arrest. Looks like it was the underlying offenses of arson on all of those count cases.
Based on the underlying offenses, Judge, we would request $20,000.
With all due respect, ma'am, I'm the only one working. My girlfriend just lost her job. I have a 3- and 4-year-old little boy. They're turning 4 and 5 next month. I'm the only person working. We just moved into an apartment on December 1st. For a $20,000 bond.
Well, let me just let you know, sir, generally on violation of probation, for violation of probation, there's usually no bond set, so I'm just reviewing what kind of a bond I think should be set.
Yes, ma'am.
Like you were sentenced to 4 years in prison, followed by probation for 10 years.
Yes, ma'am.
So you served your prison sentence and were released.
Yes, ma'am. I've abided by everything through probation. I've passed every year analysis test. I've given no issues. I violated one time. That was picking up my girlfriend from work. My child was in the car with me. I had no license. That's
All right.
all.
So in each of the 6 violations of probation, I'll set a bond of $1,000 cash or surety. So your total is going to be $6,000 on the violations and $1,000 on your new battery charge for a total of $7,000. You have court dates for the violation. Arraignment set with Judge McKibben on February 26th at 9 a.m. And on the new case battery, it's before Judge Brown on February 13th at 9 a.m. That's all, sir.
Yes, ma'am.
Are you Matthew Walensky?
Yes.
On those last ones, on the violation of probation, report to probation within 24 hours of release or first business day after release. You've been arrested, Mr. Walensky, you've been arrested and charged with driving under the influence and a violation of probation, I believe, on the underlying offense of driving under the influence. It says violation of probation.
Well, they had a warrant out for me, but I was.
So it's an. I'm just reading what it says here in the docket.
I didn't get to go to court for that yet, though.
Is it on the DUI or is it on something else?
It's on the DUI. Well,
Thank
it's
you.
a second charge, yeah.
That's fine.
Your Honor, do you have a pretrial release profile sheet for this defendant?
I don't know yet. I'm trying to get his file pulled up on the computer first. Yeah, it says failure to appear for jury trial is what the.
Yeah, no, I was in Circles of Care when that was happening, and my probation officer knew that. We actually have a plan to send my probation back home.
Looks like he pled or was sentenced in September. Looks like violation report was done with an affidavit of violation. And a warrant for violation of probation was signed on January of 2018. Judge Brown said the bond of $5,000 cash security.
The warrant I see is January 9th, but I do see the $5,000 bond.
Yeah, while I was in there, I talked to my probation officer, and also my mom got in contact with her, and they're trying to they wanted me to go to rehab for the 28-day program for that Twin Oaks or whatever it's called, and they're going to send my probation back to PA.
All right.
Because that's what my support system is back. I have no one down here, so I was going to call today, but I'm here.
You've been picked up on the violation report, and so hearing is a hearing or arraignment. I think this is a hearing is set for February 26th, 1:30 with Judge Brown. And the bond that he asked for was $5,000 cash surety. Under the circumstances, I find that's reasonable. I'll go ahead and set $5,000 cash surety. And if you are able to post the bond, your report to probation within 48 hours of your release.
Yeah.
And do you have an attorney, sir?
No.
You want one?
Yeah.
Can you afford to hire one?
No.
I'll appoint a public defender to represent you. That's all, sir. Is that all of them except the translating?
Yes, Your Honor, it is.
All right, so we have at least 4, I think.
Yes, ma'am, starting back at docket number 14, Durantes.
I'm just looking at the various ones I have. I have Nieves Allegro, I have Manuel Durantes, I have Pineda Durantes, and Salinas Lopez. Is that correct? Okay. So we'll get language line on the line, and I'll ask them to stay on for 4 cases. Yes. Thank you.
Welcome to Language Line Solutions. Please enter your 6-digit client ID. For Spanish, press 1, or please enter the 5-digit extension. Please hold for an interpreter.
Thank you very much for calling Language Line Solution. This is Felicia, 113250. I'll be your Spanish interpreter. Do you need me to place a call for you?
No, ma'am. This is Judge Rainwater. I'm calling you from open court. We have 4 defendants in custody that need a Spanish interpreter, so I'd like to go through those one at a time with you.
Not a problem. Thank you. I'm ready.
All right. The first one is Carlos Pineda Durantes. Is that you, sir? Can you hear?
Yes.
Hi. Can you hear the interpreter as well?
Buen día, señor Carlos Pineda. ¿Usted me escucha?
Sí.
Yes.
All right. Sir, you are charged with several game and fish violations.
Sí, usted ha sido acusado de varias violaciones de juegos.
They involve illegal use of nets larger than 2,000 square feet.
Y de pesca, el uso de redes más allá de 245 pies.
Possession of over the bag limit of mullet.
Y también de poseer más del límite en la bolsa.
Possession of snook during close season.
Possession of what, I'm sorry?
Snook, it's a type of fish.
Sí, posesión de smoke o un tipo de pescado fuera de temporada.
And looks like violation of size limits regarding red drum redfish.
Y también la violación 5 es acerca del pescado rojo.
Possession of over limit or undersized bluefish.
Y también posesión de más del límite o pues, de pescado azul menor del tamaño accesible.
And violation regarding prohibitions for blue crab.
Y también la violación tiene que ver con el cangrejo azul.
And fishing or hunting with without a valid fishing license.
Y por estar pescando y cazando sin una licencia válida.
The 2 primary charges of illegal use of nets are felonies.
Sí, las 2 cargos principales es el uso ilegal de la red. Eso es un delito, un crimen.
I believe, can the state help me with this? Are they punishable by up to 5 years in prison?
Oh, I was just looking at that, Your Honor.
I believe they're third-degree felonies punishable by up to 5 years in prison.
I believe you're correct.
Creo que son crímenes de tercer grado, delitos de tercer grado, y que se pueden castigar con hasta 5 años de cárcel.
Do you have an attorney to represent you, sir?
¿Usted tiene un abogado que lo represente, señor?
No.
You have a right to have an attorney to represent you. If you can't afford to hire one, I will appoint one for you.
Si usted tiene, perdone, el derecho de tener un abogado que lo represente, si usted no puede pagar un abogado, yo voy a asignarle un abogado de oficio que lo represente.
Do you wish me to consider appointment of counsel?
Quiero que yo considere asignarle un abogado.
Sí.
Yes.
Based on your affidavit of indigence, I'll find that you qualify for appointment of the public defender.
Sí, basado en su declaración jurada de ser un indigente, yo encuentro que usted califica para ser asignado a un defensor público.
The paperwork I have indicates that you live in Maryland. Is that accurate, sir?
No.
El documento que yo tengo indica que usted vive en Maryland. ¿Es eso correcto?
No.
Where do you live, sir?
No.
North
¿Dónde
Carolina.
vive, señor?
North Carolina.
North Carolina, ma'am.
Do you have any ties to Brevard County, Florida?
Sorry?
Do you have any ties, relatives, or other things holding you here in Brevard County, Florida?
¿Usted tiene algún pariente, familiar o algo que lo tenga acá en Brevard County, en Florida?
Mi familia que me espera para regresar a casa, solamente vine de vacaciones. Me invitaron a una fiesta y al siguiente día igual me invitaron a ir de pesca. Las redes no son mías. No.
Bueno, un momento, por favor. Interpreter is asking an opportunity to interpret. My family who is awaiting for me to go back home. I am here on vacation because they invited me to a party. Likewise, the following morning they invite me to go fishing. The nets are not mine. This is where interpreter asks him to hold.
All right, let me interrupt and advise you of some of your rights, sir.
Permítame interrumpir para poder decirle cuáles son algunos de sus derechos, señor.
You have a right to remain silent.
Tiene derecho de permanecer callado.
Anything you say today can be used against you at a later hearing or at the trial of your case.
Cualquier cosa que diga hoy podrá ser utilizada en su contra en una audiencia más adelante o en el juicio en su contra.
Today is not the day to try the facts of your case.
Hoy no es el día en el cual estamos haciendo un juicio de los hechos en su caso.
The court merely needs to find probable cause for your arrest and to determine what the bond should be set at.
El juzgado en el día de hoy está tratando de encontrar las causas probables para su arresto y de encontrar una fianza de ser posible para su liberación.
Has the state reviewed the information or the paperwork?
Yes, Your Honor.
¿El Estado ha revisado la información o el documento?
Yes, Your Honor.
And
Sí, su señoría.
do you wish to be heard regarding the bonds?
No, Your Honor, we defer to the court.
¿Desea ser escuchada en cuanto a la fianza? No, su señoría. Nos referimos al juzgado.
I've appointed the public defender. Are you able to speak with him, or you have?
Judge, what would you like to know? I mean, what is important to the court?
Well, the bonds of $8,000 cash as surety are I mean, they're probably scheduled bonds, but it seems a little high for.
Yes,
defense.
Judge. What I was going to suggest to the court was $1,000 each on the two felonies, and then $500 each on the subsequent misdemeanors. Or actually $250 on the misdemeanors each.
All right. My interpreter, were you able to hear that?
Part of it, ma'am. I would like for you, the person to repeat for accuracy's sake, please.
My suggestion to the court would be that count one be $1,000.
Sí, el abogado del Estado está indicando que su sugerencia al juzgado es que para la acusación número 1, la fianza sea de $1,000.
And count 2, $1,000.
Para la acusación número 2, $1,000.
And counts 3, 4, 5, 6, and 7, $250 each.
Y para las acusaciones 3, 4, 5, 6 y 7, $250 cada uno.
All right. The state wish to be heard regarding those requests?
No, Your
¿El
Honor.
Estado quiere decir algo acerca de esas sugerencias?
No, Your Honor.
No, su señoría.
I'll accept the suggestion and reduce the bonds as requested. So counts 1
Voy a
and
aceptar la sugerencia. Voy a aceptar la sugerencia y voy a reducir las fianzas como ha solicitado.
counts 1 and 2 will be reduced to $1,000 cash or surety.
Las acusaciones 1 o 2 serán reducidas a $1,000, ya sea en efectivo o con garante.
Counts 3, 4, 5, 6, 7 will be reduced to $250 cash or surety.
Y las acusaciones 3, 4, 5, 6 y 7 serán reducidas a $250, ya sea en efectivo o con garante.
And I'll set the bond at count 8 for, actually, that's a civil infraction. All right. So I don't need to set a bond on count 8.
Y la infracción número 8 es una infracción civil, así que no tengo que establecer ninguna fianza para la número 8.
I also will advise you, sir, that there are certain mandatory minimum fines on several of these counts. You should talk with your lawyer about those.
Sí, también necesito decirle que hay algunas fianzas mínimas obligatorias que hay que pagar para estas acusaciones. Necesita hablar de eso con su abogado.
Your arraignment is scheduled for February 8th of 2018 at 8 o'clock in the morning.
Su lectura de cargo está establecida para el día 8 de febrero del 2018. This is your interpreter at what time, please?
8 a.m.
A las 8 a.m.
And that will be at the Air Courthouse before Judge Ingram.
Y va a ser en el juzgado de Beard delante o ante el juez Ingram.
Do you have any questions for the court, Mr. Durantes?
Señor Durantes, ¿alguna pregunta para el juzgado? ¿Perdone?
He's speaking to the lawyer at the moment.
Oh, disculpe.
All right, that's all, sir. Madam Interpreter, we have a few other cases, so I'll get to those in just a moment.
Not a problem, ma'am.
This is docket 30, Your Honor.
Thank you. All right, you are Jonathan Manuel Durantes? Is that correct?
Sí.
All right.
¿Usted es Johnson Manuel Durantes?
Sí, correcto.
Yes.
And were you
That's
able?
correct.
Were you able to hear everything I told the other Mr. Durantes? Were you listening?
¿Escuchó todo lo que le dije al otro señor Durante?
All right. So the charges against you are identical to the ones against Mr. Pineda Durantes.
Los cargos en su contra son idénticos a los que estaban en contra del señor Pineda Durantes.
Are you and he related to one another?
¿Ustedes están emparentados? ¿Son familia?
Sí,
All right. And you were arrested at the same time?
¿Fueron arrestados al mismo tiempo?
sí, andamos toda la familia juntos.
Yes, the whole family was together.
All right. Do you have an attorney to represent you, sir?
¿Usted tiene un abogado que lo represente, señor?
No.
Do you want an attorney?
No. ¿Quiere un abogado?
Sí.
Yes.
All right. I'll appoint a public defender to represent you.
Le voy a asignar un defensor público que lo defienda.
I understand that you may have a conflict, but I think, Mr. Durantes, are you from Brevard County or from someplace else?
No, I'm coming from Maryland
Maryland, okay.
for 1 week.
So you can see if there's a conflict and address it. Public defenders indicate there might be a conflict, but I'm going to postpone addressing that conflict to see if there's an actual conflict. Madam Interpreter, would you explain that?
El abogado defensor público dice que puede haber un conflicto, pero yo voy a posponer ese conflicto del que él se está hablando para ver, debido a la dirección, pero voy a ver si hay un conflicto en realidad.
Does the state have any objection to addressing the bonds on this Mr. Durantes as well as the other one? Same?
No, no objection.
And Mr.
¿El Estado tiene alguna objeción en hablar acerca de las fianzas de este señor Durante, que son las mismas que el otro? No.
Mr. Public Defender, I assume
Objeción.
you would be recommending the same bonds?
Yes, ma'am.
All right.
Estado, ¿usted va a recomendar la misma fianza? Sí, su señoría.
So, sir, I'll set your bonds on counts 1 and 2 at $1,000 each.
Y la fianza, señor, para usted entonces, para la primera y segunda acusación, será de $1,000 cada una.
And on counts 3 through 7, I'll set them at $250 each.
Y de la acusación 3 hasta la acusación 7 será de $250 cada una.
And I'll also advise you that you need to speak with the lawyer regarding minimum mandatory fines on several of these charges.
Y necesita hablar con un abogado acerca de fianzas o multas mínimas obligatorias para algunas de estas acusaciones.
And your court date is set for arraignment on February 18th at 8 a.m. with Judge Ingram in Vieira.
Sí. Y su lectura de cargos está establecida para el día 18 de febrero a las 8 a.m. ante el juez Ingram en Viera.
Puedo decirle algo, que yo vivo en Maryland y me voy para allá y tengo que venir de vuelta, son 15 horas, no sé cómo podamos hacer ahí.
Speak toward the microphone.
I would like to say something. I live in Maryland. Do I have to come back here because it's 15 hours? The trip will be 15 hours.
All right. All right. So, Mr. Durantes, you will need to show up for court or talk with your lawyer about what arrangements can be made otherwise. I have appointed counsel for you.
Le he asignado un abogado.
That's all, sir.
Thank you. Docket number 34.
Oh, same thing. Your name, sir?
Anselmo Nieves Alegria.
All right. Sir, you were listening to both the prior cases? Were you listening when I just explained some things?
Then this is the interpreter, Your Honor. Does Mr. Anselmo need an interpreter or not? I believe I'm hearing him answer.
All right, I was told that he did need an interpreter. Do you speak English, sir?
Just a little.
He speaks just a little English.
I use it here.
Okay. Can the deputy point the microphone a little better? Maybe not. Thank you. All right. So, Mr. Alegría, you are charged with the same offenses as the 2 prior defendants. Did you hear those charges?
Señor, usted tiene los mismos cargos que los otros defendidos anteriores. ¿Usted escuchó esos cargos?
Sí.
And are you also, are you related to them as well?
¿Usted es pariente de ellos? ¿Está emparentado con ellos también?
Sí, uno es mi sobrino, Manuel es mi sobrino, Carlos, mi primo y el otro amigo.
Manuel is my nephew, Carlos is my cousin, and the other one is my friend.
And you also live out of state?
¿Usted también vive fuera de este estado o vive aquí?
Maryland. We come for vacation.
So you're from Maryland, sir?
Yeah.
Does the state have any objection to setting the same bonds?
No, Your Honor.
All right.
El estado no tiene ninguna objeción en programarle la misma fianza.
So in counts 1 and 2, I'll set the bonds at $1,000 cash as surety.
Así que en la acusación 1 y 2, la fianza es de $1,000 cada uno, ya sea en efectivo o con garante.
Counts 2, 3, 4, 5. Excuse me. I'll start over again. Counts 3, 4, 5, 6, and 7. The bond will be set at $250 cash as surety.
Sí, las acusaciones 3, 4, 5, 6 y 7 tienen una fianza de $250, ya sea en efectivo o con garante.
And you also need to talk with your lawyer about minimum mandatory fines on several of these charges.
Y también tiene que hablar con su abogado acerca de las multas mínimas requeridas para alguno de estos cargos.
Do you have a lawyer to represent you, sir?
¿Ya tiene un abogado que lo represente, señor?
No.
No.
Can you afford to hire a lawyer?
¿Usted puede pagar un abogado? ¿Contratarlo y pagarlo?
No.
And he said he qualifies. I'll go ahead and appoint a public defender to represent you. And again,
Voy a asignarle un defensor público para que lo represente.
and if the public defender perceives a conflict, they'll let us know and we'll appoint separate counsel.
Sorry?
If the public defender sees a conflict, they'll let the court know and we can appoint separate counsel.
Si el defensor público ve que hay algún conflicto, ellos le notificarán al juzgado y vamos a entonces asignarle un asesor separado.
And your arraignment is set for February 8th at 8 a.m. before Judge Ingram and Vieira.
Y su lectura de cargos es el 8 de febrero a las 8 a.m. frente al juez Ingram and Vieira.
Thank you, sir. That's all. I'm sorry, is there something you wanted to say?
¿Puedo decir algo?
¿Hay algo que quiera decir?
Sí.
Yes.
Respecto a mi primo Carlos, la confusión que ella dice con la dirección es porque él dijo solamente que vivía en North Carolina, pero él vive en Charlotte, el estado de Charlotte.
¿Cómo no?
Pues no, pero él solamente dijo North Carolina, pero
Carolina del Norte es el estado.
por eso.
Es lo que le estaban preguntando.
Sí.
Lo entienden bien.
Okay. Y
Did he answer your question, sir?
yes, yeah.
All right.
El abogado contestó su pregunta. El señor contestó su pregunta.
Sí.
All right. Thank you. That's all. That's all, then, sir.
Gracias, es todo.
And we have one more case, Madam Interpreter.
Yes, Your Honor.
All right. State your name, please. Could you hear
Luis
me?
Santiago Salinas López.
And you're also charged with the same, essentially the same offenses?
¿Usted también tiene las mismas acusaciones?
Do you have an attorney to represent you, sir?
¿Usted tiene un abogado que lo represente,
No.
Do you want an attorney?
¿Quiere un abogado, señor?
Sí.
Yes.
Can you afford to hire an attorney?
¿Usted puede pagar un abogado por cuenta propia, señor?
No.
No.
I'll go ahead and appoint a public defender to represent you.
Le voy a asignar un defensor de oficio público, para que lo represente.
Okay.
And I will set the bonds as I did on the other cases, 1,000 cash as surety on counts 1 and 2.
Voy a establecer la misma fianza que los otros, $1,000 en las acusaciones 1 y 2, ya sea en efectivo o con garante.
And on counts 3 through 7, I'll set the bond at $250 on each count.
Y de la acusación 3 a la 7 será $250 en cada una de las acusaciones.
Actually, Mr. Salinas Lopez, you live in Orlando?
Yes.
Señor Salinas López, ¿usted vive en Orlando?
Yes.
All right.
Sí.
Yes.
And, all right. State have any discussion regarding the bond since he's local rather than out of state?
El Estado tiene algo que decir en cuanto a la fianza, ya que él es local y no es foráneo de otro estado.
No, está bien.
Judge, the state would prefer that they all be the same, but defer to the court.
Public defender?
Bueno, puede ser todos los mismos, pero deferimos al juzgado. Nos referimos al juzgado.
Judge, if you're inclined, I think a bond's still appropriate, but you could make it less. I mean, $500 apiece on the felonies, I guess. I mean, I think my point is, Judge, unless you're inclined to straight ROR him, I think a bond's better than community supervision because he does live out of the county.
All right.
Out of the county, that would make it more difficult, I believe, simply because they require the reporting.
All right.
Su señoría, si usted decide y bien quiere, creo que una fianza será más recomendable que el servicio comunitario, ya que él vive fuera de del condado. Para efectuar servicio comunitario fuera del condado es algo engorroso, ya que solicitan que él se reporte.
All right. I'll leave the bonds set as they are. As I stated.
Justamente como están.
So you'll have an appearance before Judge Ingram on February 8th at 8 a.m.
Su comparecencia es frente al juez Ingram el 8 de febrero a las 8 a.m.
Okay.
All right, that's all, sir.
Es todo, señor.
Hey, I've got some great news to share with you folks if you haven't heard. You haven't heard? Court TV is back. We are relaunching May of 2019.
Assistance of a Spanish interpreter in Osceola this morning. Good morning, this is Judge Starr. We're ready to get started. Anybody need a Spanish interpreter? We don't have one, I'm just asking.
You do not have a Spanish interpreter?
No.
She probably get here to about 11.
We do. We have two people who do require the assistance of a Spanish interpreter.
All right, well, they're going to have to wait because the Spanish interpreter is not here.
She's coming, but she won't get here till probably about 11. She may, so we can start Osceola and hopefully she'll
We'll
be.
go back,
Yeah.
maybe. We'll see.
Yeah.
You have to be wishy-washy today.
Okay.
All right. All right, so Jerry Isa.
Your
Oh,
Honor,
can you-
think he's bonded.
You're bonded. Can you put your name on the record?
Yes. Good morning. My name is Allison Lopes. I'm with the Public Defender's Office.
Wonderful.
And you may
Okay.
test on behalf of the state.
And, all right, thank you. All right, Jared, he bonded. Jared Allred.
Your Honor, Mr. Allred is present. He's in the back.
All right, Mr. Allred, you're here on violation of probation. I reviewed the affidavit, find probable cause, and set your bond at none. This concludes your hearing this morning. Good luck to you, sir. Christian Amasquita. Good morning. How are you?
Good morning, Your Honor. I'm doing fine. How are you?
I'm well. Thank you so much for asking. All right, looks like you're here on failure to appear. You have you had a felony case, 17 CF 2725, failed to appear, and so now there was a warrant out for you, and that looks like revoked your old bond if you had one. Now you do not have a bond. There's no bond in your case.
Your Honor, Mr. Amasquita provided me with some information that there was some miscommunication between himself and his attorney on the court date, and then he did turn himself in on January 9th once he realized that there was this warrant available. Would the court consider setting a bond given those
But you could definitely talk.
circumstances?
You can definitely talk to the judge and have your lawyer file the appropriate motions. For now, I'm going to leave it the way the judge had requested, and that is all. In all the cases this morning, I'm appointing the public defender for the record. Thank you so much.
Can you answer what's the case
Thank you, Your
number
Honor.
on this DOP on all red, because I couldn't find it. And I need it for the order. I looked, but I didn't find the case number.
Do anybody have a case number for Mr. Allred on the underlying VOP?
No, Your Honor, it's not stated in the affidavit.
It's pre-trial over there. Pre-trial release, do they know?
Does the pretrial release know?
Your Honor, Pat Hill with PTR. I don't have it in front of me, but I could get it after the court and email it over. I
just want to let it know
if that would work.
All right, it's not going to be on the order because we don't have it in the file.
Do they have a DOC number?
Do you guys have his DOC number? We can look it up over here.
What would his name is? Is it a felony VOP or a county?
It's a felony VOP.
Is there like a DOC number?
He's from Osceola.
No,
What's his
Your
last
Honor,
name?
if you can give us a couple minutes, we can
All
get
red,
that for you.
ALLRED.
What's the first name?
JARED. Middle name, Michael.
Okay, date of birth 10/10/98.
Yeah.
Yes.
All right, his case number is 2016. He has two of them. 2016 CF 3736, 2017 265. So it's 2016 CF 3736 and 2017 265. And that's out of Osceola.
He on probation on both of them?
Yes.
So I don't know which one he's
The
in.
occupied burglary from 2017.
So the 2017 case?
Yeah.
So we're just going to do it for the 2017 case?
Yeah, that's it.
Okay, good. Thank God. That's the.
He's on probation
Just save
for
my life,
occupied
yeah.
burglary, which
It's a
began
2016 case.
Okay, so we'll do it for the 2016.
2016, sentenced in on October 23rd, 2017, and that's what happened.
Okay, so
Yeah, that's it.
we'll do that
Okay.
case number, okay.
All right, thank you.
Sorry, Judge.
No, thank you. Kareem Carter. Hi. Kareem Carter. Mr. Carter, you're here on 2 counts, commit felony battery and grand theft auto. I've reviewed the affidavit, find probable cause. No contact with the victim. Your bonds are set. None. Well, hold on. For the felony battery, For the felony battery, it's $8,000 bond. For the grand theft auto, it's a $2,500 bond. No contact with the victim, no return to the scene. No weapons. Good luck to you, sir.
Thank you, Your Honor. Have a blessed day.
Thank you. Brenton Compton. Mr. Compton, you're here on for an active warrant from Osceola County for burglary and grand theft. There's no bond in your case. This concludes your hearing. Good luck to you. Do you need something?
No, Your Honor, Spanish interpreter's present.
Oh, great. Thank you so much. Perfect timing. All right, we have two in Osceola. I don't know who they are, but they'll come up. Julio Cesar Rosa Martinez.
Yeah, the interpreter is there. Your Honor, he needs a Spanish interpreter. Is the interpreter there?
Yeah, and have you been sworn in yet?
No, Your Honor.
You gonna do it? All right. All right, do you solemnly swear to interpret from English to Spanish and Spanish to English to the best of your abilities?
I do. This is Jorge Bonilla, state certified court interpreter.
All right, wonderful. Julio Cesar Rosa Martinez.
Sir?
Is that you, sir?
¿Usted es Julio César Rosa Martínez? ¿Sí o no?
Yes.
All right.
Your Honor, before you go forward, I do have some information from PTR that he does qualify for direct PTR release, Your Honor.
Señoría, antes de que usted proceda, tengo información de la Oficina de Libertad con antelación a juicio de que él sí cualifica para libertad con antelación a juicio.
Yeah, even though he gave the officer a false name?
Aunque le dio un nombre falso al oficial.
He has been identified, Your Honor, as Julio Rosa Martinez, and they did so with his fingerprints. So his identity has been confirmed with PTR.
Él ha sido identificado como Julio Rosa Martínez y eso fue a través de huellas digitales, así que sí, la Oficina de Libertad con antelación a juicio. Hang on, Ms. Lopes.
I think he did give them the correct name.
Y creo que sí, la víctima tiene el nombre correcto.
All right. Order pretrial release.
Ordénese libertad con antelación a juicio
And I do find probable cause.
y determino causa probable.
Good luck to you.
Buena suerte.
Thank you, Your Honor.
Thank you. Tony Green.
Your Honor, Miss Green is currently in detox. Can we reset her?
Okay, reset Ms. Green for tomorrow.
Thank you, Your Honor.
Julia Kearns.
Your Honor, I've been told that Miss Kearns is also detox and she's in medical, and I'm asking to reset her for tomorrow.
All
as
right,
well.
reset Ms. Kearns for tomorrow. Alice Matheny.
Same thing with Miss Massney, Your Honor. She's also detoxing. Can we reset her for tomorrow?
Okay. Marcelino Montes Lebron.
He will need the assistance of the Spanish interpreter, Your Honor. He's present.
Okay. All right. Good morning, Mr. Montes Lebron.
Buenos días, señor Montes Lebrón.
You are here on You are here
Good
on.
morning, Your Honor.
Thank you. You are here on 2 counts.
Usted comparece aquí acusado de 2 cargos.
Aggravated assault with a deadly weapon with intent to kill.
Amenaza agravada con arma mortífera con intención de matar.
And simple battery.
Y agresión simple.
I reviewed your affidavit.
Revisé su affidavit.
Find probable cause.
Determino que hay causa probable.
Set your bonds as follows.
Y se fijan sus fianzas según sigue.
$15,000 for count 1.
$15,000 en el primer cargo.
$500 for count 2.
$500 en el segundo cargo.
No contact with the victim.
Se le prohíbe el contacto con la víctima.
No return to scene.
Se le prohíbe el regreso al lugar de los hechos.
No drugs, no weapons.
Se le prohíbe la posesión o tenencia de armas o drogas.
This concludes your hearing this morning. Good luck to you, sir.
Esto concluye su vista en la mañana de hoy. Buena suerte, caballero. What's the total?
Thank you, Your Honor. I'll tell you in a minute.
Dominic Placewell. Dominique Chantel Placebal.
Hello. Good morning.
All right, good morning. You're here on an active warrant out of Osceola for a violation of probation, and there's no bond in your case, ma'am. This concludes your hearing this morning. Good luck to you. Kenneth Purvis.
Your Honor, Mr. Purvis is here as a result of an ordinance violation. He's currently homeless, unemployed. I'm wondering if the court would consider a straight ROR or PTR type release instead of a bond, which was set at $250.
I got an address I can't use, my dad's. And Your Honor, it was no disrespect, and I'm truly working on it. I mean, it is on the paperwork. I wasn't going to disrespect the store. I went under a palm tree.
But you know
and
what?
I didn't even finish half a beer.
He has open
Yes, ma'am?
trespass, open resisting, and a disorderly. So no, the motion is denied. The bond's set at $250. Probable causes in the affidavit. Good luck to you, sir. The two open cases will leave alone.
So what am I basing?
No action. Okay. Yeah. All right. Next case is Kevin Veselowski.
Morning, Your Honor.
All right, good morning. It looks like you're here on a violation of a domestic injunction. I reviewed the affidavit. You were going to say something?
Your Honor, I was just going to, yes, if you don't mind, Your Honor. I spoke to Mr. Veselowski. It appears that he also has no employment at this time, is also living, is homeless, really does not have a place to stay, and we're asking if the court would consider some type of PTR or ROR release instead of setting a monetary bond.
All right, the motion's denied at this time. Your bond is set at $8,000. No return to the scene, no contact with the victim, no drugs, no alcohol, no weapons. Next case, Anthony Williams. Mr. Williams?
Mr. Williams is present, Your Honor.
All right, Mr. Williams, you have...
morning, Your Honor.
Good morning. You have an arrest warrant for your charges signed by Judge Martinez. Cocaine, selling cocaine within 1,000 feet of a municipal park, conspiracy to sell cannabis, and delivery of drug paraphernalia. Those are the three counts.
Your Honor, it appears that in the arrest affidavit, the police indicated that the cocaine count was an error, and basically the marijuana and the drug paraphernalia counts are correct. So I'm wondering if the court could take a closer look at that.
I'm sorry, I'm looking at the arrest affidavit too. So, what do you, please direct me to what you are saying. What do you see it?
Just one moment, Your Honor, I'm going to pull it up.
What do you ask? What are you saying? What page? What line? Where are you addressing this? I see the total net weight of the crack cocaine that was sold by DeAndre Deshaun Montgomery was 0.1 grams. The total gross weight of the cannabis baggie sold by Anthony Jermaine Williams was 3.3 grams. Field tests were conducted on both. Both tested positive. What? I'm sorry, I didn't understand what you were saying.
Sorry, Your Honor, I may have mixed that up with a different...
Okay, so probable cause...
No, actually, Your Honor, if you look at the second paragraph on the second page, it says, during my investigation, it was found that the warrant for sale of cocaine within 1,000 feet of a specified area, municipal park, was input in the warrant as an error. The correct charge is sale of cannabis within 1,000 feet of a specified area, municipal park. So this is on the second paragraph of the second page of the report, Your Honor.
Okay, so if I go by the affidavit and not the arrest warrant,
so
It's just the 2 counts is what you're saying?
Correct, Your Honor.
All right. And State, do you have any response?
Your Honor, the state would request additional time to actually contact the officer to discuss why that was included.
All right, let's reset it for tomorrow.
Thank you, Your Honor.
So you're giving it 24 hours?
Thank you, Your Honor.
24-hour review. All right, thank you. John Wolford.
Your Honor, Mr. Wolford is not here at this time. He is in BA. Have indicated, the jail has indicated that he's made some self-harm comments.
So reset him for tomorrow. Victor Zavala.
Your Honor, I have some information that he also qualifies for direct PTR.
Reset him for tomorrow. He was self-harming.
Okay.
All right. All right, Mr. Zavala, I reviewed your affidavit, find probable cause, set your bond at $500. All right, this
Thank you, Your Honor.
This concludes the Osceola initial appearances for January 15th. Thank you. Let's get on the record.
Hey, if you love watching what's happening inside courtrooms, there's no better place than Court TV, because Court TV is back. We are relaunching May of 2019. Stay tuned for local listings.
And we're on the record with Mr. Fisher. Good morning, Mr. Fisher.
Good morning, Your Honor.
You have Cheyenne Romel Williams?
Yes, Your Honor.
All right, so you said the old DUI was dismissed?
I was advised that the old DUI was dismissed because he finished pretrial diversion.
Okay, I'm not going to take any action on that case then.
We got to get him in here. You guys going to get him, right? Okay. And then the traffic.
Oh, I'm sorry. Standing on the wrong side.
Old habits.
Well, it switches based on what courtroom you're in.
Yeah. All right, good morning, Mr. Williams. How are you?
I'm good, ma'am. How are you?
I'm well. Your lawyers asked me to waive the formal reading of the charge, but I did find probable cause, setting your bond in that new case at $7,000. You're to have no contact with the victim, no return to the scene, no drugs or alcohol. You had a pending case, a misdemeanor DUI. I'm taking no action in that case. This concludes your hearing this morning. Good luck to you.
Your Honor, one thing.
Yeah.
The no return, it's his mother's house. Should the victim move and no longer live there, is he then allowed to return?
It'll be no contact
So,
and separate residences.
Okay, so instead of no return, it's no contact, separate residence.
Yes.
Thank you.
Thank you.
Thank you, Your Honor.
Just maintain separate.
Maintain separate residences, no contact. Yeah.
And you said that how much?
7,000.
7,000.
All right. And you had Robin McIlwain.
McIlwain, although it's now Robin Waite, is her real name.
Okay.
I mean, McIlwain was her maiden name from 30 years ago.
Hi, is that you? Are you Robin McIlwain, formerly Miss McIlwain? All right. State, do you have an announcement or a request?
The state will be no crossing the VOP as well as the, just the VOP.
All right. So I'm going to dismiss the probation violation warrant, and this concludes your hearing.
Your Honor, would the court revoke and terminate probation just to make
Yeah,
sure
just to
it's
make
all
it clear,
over?
revoke, terminate,
Okay,
dismiss.
okay. Shh, hold up. I'm sorry, you guys. This is a traffic case. Okay, she got, I know it's a back in 86 case, and she have custody supervision, she got balance, she got a lot of stuff going on, so I don't know
Yeah, that's
how
true.
much it is because of the case. I mean, we can set her a bond, or you want to lease it, because she will be going to
I'm going to give you
court.
300 days to pay all of your outstanding costs in this case. I'm going to give you,
See, that's it. I still.
I'm going to give you 7 days to report to the clerk's office to figure out what your costs are. Can we do that? No? And if otherwise your license is going to be suspended?
Because with traffic, it's nothing in the case. I don't know. We have to pull the file. It's going to take a little longer to pull the file.
I see that she owed $352.
That's for the custody supervision, but I don't know what's up in our system because it's an 86 case and we converted to Obviously, a lot of stuff is not in there, so we
Right.
have to order the file. I don't know what.
So
the
can I
balance-
make stuff up now? Can I make new stuff up now?
I don't know.
Because I have a fine of $255, court costs of $64.50, $12.50 surcharge, crime compensation costs of $20, and I think those were the allegations, and that probationer failed to pay fine totaling $352.
She owes $352.
That's the total.
Thank you, Your Honor.
So it's,
So she owes
so you're
$352.
going to revoke and terminate probation.
Yeah, dismiss the affidavit,
Or the.
revoke and terminate probation,
Dismiss the BOP.
and give her 300 days to pay
Outstanding balance.
of $352.
Outstanding balance, 300 days. I don't know, this is traffic, I'm gonna have to.
And if she doesn't pay it, D6 is her license.
Right,
Okay.
license gets
So
suspended.
you have 300 days to pay $352 to the Orange County Clerk of Court.
3-6
Okay.
license.
If there's no probation, warrants are gone, case is dismissed, it's all over. If you don't pay in the next 300 days, then they'll D6 your license. Okay, so just pay it.
Say again?
Division.
What division is this? 83. No, I'm sorry.
Yep.
It was? No.
Bell, Judge Bell.
Yes, that's right, 83, yeah.
And can she mail in a check for the costs or pay by phone through the credit card or something, Madam Clerk?
It's either clerk's office or Amscot. I don't think there's any other way to do it. You're gonna give Sharon a heart attack.
Nope, I'm just writing down court dismissed VOP, revoke terminate probation, outstanding balance paid in such. That's all I can do.
But you have 300 days to figure it out.
Okay.
All right. Thank you. Good luck to you.
Thank you, Your Honor.
Have a great day. All right. Is this Belinda Graham?
Yes, ma'am.
All right. You're here on a domestic battery charge. I reviewed your affidavit. Find probable cause. Set your bond at $2,500. No contact with the victim. No return to the scene. No alcohol. No drugs.
Judge, Rhiannon Arnold Rogers on behalf of Ms. Graham. The alleged victim in this case is her son. He does not live at that residence, as he told law enforcement. I have his updated address.
Okay. So instead of no return to scene, maintain separate residences.
And no, but remain with no contact.
No contact.
And how much was the bond?
$2,500.
And Judge, I believe she would be eligible for PTR. Would the court be inclined to reduce her bond and give her PTR?
All right. I'll order the pretrial release.
Thank you, Your Honor.
Okay, so let me get PTR. All right, thank you.
Thank you, Your Honor. I'm just going to step over to your clerk so I can give them the updated address
Yep.
for the son.
All right, so are we ready to get started with the normal progression? Evelio Lace Gomez. Where'd Miss Martin go? Is she back there? Uh-oh. All right, and for all the cases we're addressing now, I'm going to appoint the public defender to all of them. And now, if we could just find what happened to Miss Martin. We'll just wait for her.
That was an old case.
Oh, looks like we have some people coming in, too.
Yes, Judge, there were numerous people downstairs, but were not allowed upstairs until you began.
Okay, thanks. All right, Miss Martin, you ready? Evelio Lace Gomez. All right. Any victims here for Evelio Les Gomez? Evelio Les Gomez. Okay, I don't see anybody coming up. Sir, I've reviewed your affidavit. It alleges a battery. a false imprisonment, and providing false identification to law enforcement. I find probable cause. Set your bond as follows. It's $5,000 for the first count, $150 for the second count, and $100 for the third count. There's no contact with the victim, no return to the scene, no drugs or alcohol. This concludes your hearing. Good luck to you. Esteban Lopez.
We'll get the next one.
Shazbat.
We got a big group.
Juez.
Oh, that's what, Quez? Oh, I said.
Juez.
Quez. Oh, the just. Okay.
Esteban Lopez. Anybody here for Esteban Lopez? All right. Mr. Lopez. All right. Looks like you're here on a charge of aggravating battery on a pregnant person.
Señor López, usted comparece aquí acusado de agresión agravada contra una persona embarazada.
All right. I've reviewed the affidavit.
He revisado la affidavit.
Find probable cause.
Determino causa probable.
Set your bond at $10,000.
Se fijan $10,000 de fianza.
You're to have no contact with the victim.
Se te prohíbe el contacto con la víctima.
No return to the scene.
Se te prohíbe el regreso al lugar de los hechos.
And no drugs, alcohol, or weapons.
Se prohíbe la posesión o tenencia de drogas, alcohol o armas.
I see that there's somebody here for your case.
Veo que hay alguien presente en este caso.
Ma'am, can you tell me your name?
Señora, declare su nombre, por favor.
Norma Concepción. Norma
Norma, su apellido, por favor.
y Coy.
Norma y Coy.
All right. Is there anything you'd like to share with the court?
¿Habrá algo que usted quiere decirle a la corte en este momento?
Voy a hablar.
Can I speak?
Yes.
Sí, por favor.
Yo quiero hablar atrás con mi marido Esteban. Sí, yo quiero que...
Señora, ¿podría repetir eso en voz alta, por favor?
Yo quiero que van a salir y que se vaya conmigo.
I want Esteban to be free and go home with me.
Okay. All right. Thank you so much. Is there anything else you'd like to share with the court today?
Gracias, señora. ¿Algo más que usted quiere decirle a la corte?
Sí, yo quiero decir más que quiere mi marido tiene que ser el que se vaya conmigo, porque estoy embarazada y nada para uno puede que se va para mi ayuda. Es que es mi marido tiene que ser el que se vaya conmigo, pero y yo no estoy trabajando y solo él está trabajando y montando.
Okay, un momento, señora. But yes, I'd like him to go home with me. The fact is I'm pregnant and I'm not working and he's the one that's working.
Okay. All right. Thank you so much. My order stays the way it is for
Muchas
now.
gracias, señora. La orden permanece en efecto.
All right.
And Your Honor,
Thank you.
in terms of the defense to lay our record, the purpose of bond is to assure their appearance at trial. His risk assessment from the jail that when they interviewed him is a below average. He is employed part-time. He's been there for a year or longer. I mean, the no contact order can stay in place, but a $10,000 bond is tantamount to no bond. He does, again, have a below average, and the presumption is in favor of a release and bond that can actually a person can afford.
All right. I'll set it to $8,000.
Fíjese $8,000.
Thank you.
Gracias.
All right. Thank you so much, Ms. Martin. Santiago Robles Santos. Mr. Santos,
Señor López Santos,
you are here on a battery charge
compareces aquí acusado de agresión
of a
física
domestic nature.
por violencia doméstica.
I've reviewed.
Qualifies for pretrial
Y
release.
él cualifica por libertad con antelación a juicio.
One moment. The victim isn't present. Let me make sure he has an alternate address. He has no alternate address at this time. The victim isn't present, so we can't do it.
La víctima no está presente. No podemos
Okay, so there's, I reviewed the affidavit, find probable cause,
causa probable.
set your bond at $2,500,
$500 de fianza.
no contact with the victim,
Con la víctima.
no return to the
Prohíbe
scene,
regreso al lugar de los
no
hechos.
drugs, alcohol, or weapons.
Drogas o alcohol o armas.
Good luck to you, sir. This concludes your hearing.
And Your Honor, can we say or PTD if he qualifies in the event he is able to provide an alternative address?
No, denied. Hector Santiago Irizarry. Who else? Mr. Santiago Irizarry, you're here on 2 counts, unlawful act for driver's license, using false name. It's an arrest warrant signed by Judge Jewett, and the bonds are set at $1,000 for count 1 and $500 for count 2. Good luck to you, sir.
Pero yo no tengo un hold.
But I don't have a hold.
I'm sorry, you don't have a what?
¿No tienes un qué?
Yo salgo así ya.
So I get out and that's it?
No.
You have bonds, sir. Yes, I've set your bonds. You can post your bonds and get out. No. Oh, he has a hold. Oh, thank you. Okay, good luck to you, sir. William Brumel. That's all for Spanish? Yes, thank you so much. Mr. Brumel, you're here on a new case, trespass. You have an old case for battery and trespass. So on your old case, revoke your bond, and on your new case, I'm setting a bond at $500 and finding probable cause.
Your Honor, I apologize. Just to let the court know, since the system was down, we didn't get a normal docket. It's going to take me a little bit to get to it because I'm just going off of first appearance sheets. For the out on bond for the battery, he was actually released on a 33-day motion because the state indicated.
Oh, I see the ROR. All right, so I'm not going to take action on the original case. All right, so your bond's set at trespass on the new trespass at $500. No action on the old case. Timothy Lafferty. Mr. Lafferty, you're here on 2 counts, possession of drug paraphernalia and a trespass. I reviewed the affidavit, find probable cause, set your bonds at $500 and $100 respectively. This concludes your hearing this morning. Good luck to you, sir. Mr. Burnett.
Mr. Burnett is mental health now.
All right, mental health for Mr. Burnett. Mr. Johnson.
Mental health,
Mr. Johnson. Mr. Neary. Is that you?
Yes.
All right, Mr. Neary, you are here on a trespass, a fine probable cause, set your bond at $250. This concludes your hearing. Good luck to you.
There was an offer of an adjudication credit for time served made. Sorry, I couldn't get to my paper in
That's okay.
time. I don't know if you'd be willing to accept that offer. Credit for time served, you go home today, you pay court costs.
Mr. Neary, the state is offering you an adjudication and court costs. Your court costs are $273. I'll give you 300 days to pay. Do you want to resolve your case today? Or do you want to come back on a future day once you bond out, if you bond out? What would you like to do? I'll give you 10 months to pay if you're worried about the payment. Do you want to resolve your case today or no?
Today, if I can't resolve it, do I have the option to go back to what she offered, go home and then pay for it?
Yeah, you can. You don't have to resolve it today. You can bond out, fight the charges. The offer is not going to change, right, Ms. Testa? The offer is not going to change. Adjudication court costs.
No, Your Honor, and that practice is a withhold.
Oh, it's a withhold. Does he have any priors?
No, Your Honor.
I apologize.
Okay, so listen, you don't have any priors. You might even be eligible for a pretrial diversion. You have options open to you. You can bond out and figure it out. Or you can resolve it today. What would you like to do?
Your Honor, given his hesitation and some of his questions, I would just ask if it's a withhold credit for time served. There's a presumption in favor of
Does
non-monetary.
he qualify for pretrial release?
It says no, but I would be asking for ROR.
Possibly, maybe that's what Your Honor. He has a mental health detainer right now that's opened.
All right, I'm going to set the bond. I'm going to give you time to think about it. Good luck to you, sir. Next case, Mr. Waniver Revert.
He refused, John.
Okay. Hilario Celestrin. Oh, I'm sorry. Hi, how are you? All right. It looks like you're here on 3 counts: battery by strangulation, aggravated assault with a weapon, and false imprisonment, domestic. I reviewed your affidavit. Find probable cause. Set your bonds as follows: $15,000 for count 1, $8,000 for count 2, and $1,000 for count 3. There's no contact with the victim, no drugs, alcohol, weapons, no return to scene. This concludes your hearing. Good luck to you.
And Your Honor, I apologize. If I can just have a moment for each of these cases to lay something on the record. For the battery of the strangulation, the affidavit actually doesn't allege that there's no facts to support that they lost breath. That's actually required for the strangulation aspect. So there's defense's argument that there's only PC for the domestic violence. Also, the bonds that are set, that's tantamount to no bond. He's entitled to a bond. He is obviously disabled. He gets Social Security. He's a graduate of college. He's had employment for 17 years, and so we'd be asking for that bond to be reduced significantly.
Any response from the state?
Your Honor, the state, if you're not inclined to find PC today, we ask for 24 hours to speak with the officer to get the issue of lost breath on the record.
I'm going to keep it because I think that the affidavit alleges choking for several seconds. That's sufficient to me for probable cause, in addition to the 3 paragraphs before, but specifically that particular one. And I don't think the bond is that high, given the circumstances. All right, next case. Thank you, Ms. Martin, for laying the record. Edward Silva.
Yes.
All right, Mr. Silver, you're here on a petty theft and a trespass. I reviewed the affidavit, find probable cause, set your bonds at $500 and $100.
And Your Honor, is there an offer from the state?
Yes, offer would be adjudication, credit time served, court costs for today.
Adjudication on both counts?
Yes, Your Honor.
And is the trespass a first or second degree? Is it, the petty theft looks like it's a second, but what's the trespass? It's a first? Is the trespass a first or second degree misdemeanor?
It depends on how it's alleged. Is it?
After warning, is that the first? So it's 1 second and 1 first degree misdemeanor?
Yeah, that's what it looks like.
All right, Mr. Silver, you want to resolve your case by accepting the state's offer? It's an adjudication on both counts.
Do I got to pay a fine?
No, there's no fine, but there are court costs. The costs are $273, and I'll give you 10 months to pay. That's less than $1 a day.
Yeah, I'll do that.
All right, and is this your signature here on this plea form?
Yeah.
Did you review the form?
Yeah.
Do you understand that the form has all the rights you're giving up in exchange for the plea? So there's not going to be a trial. You're not going to call any witnesses. You understand all the rights you're giving up today?
Yes.
Anybody force you to do this?
No.
All right, I find you understand the rights you're giving up today in exchange for this plea. I find a factual basis to accept the plea based on the narrative in the arrest affidavit. I'll accept your plea and impose the following sentence. It's an adjudication on both counts, and court costs $273. I'll give you 300 days to pay, and you have 30 days to appeal this sentence in writing. Do you have any questions?
No.
All right, good luck to you, sir. Next, we have Corey Smith. Mr. Smith, you're here on an allegation of disorderly conduct. Ms. Martin, do you have anything to say about this?
Yeah, I don't know why the officers keep charging this as disorderly conduct. It's more tantamount to soliciting or panhandling. There is absolutely no PC.
I'm going to ROR him on this. Find no PC and ROR.
Your Honor, just for the record, I did look up the disorderly conduct ordinance in the state of Orlando. It does include not leaving the street after being requested by an officer, so we actually request 24 hours to ask the officer for additional information.
All right, the next one, you can tell me that faster.
Okay,
for now,
thank you.
he's going to be ROR'd. All right. Okay, Ross, and if you have a copy of it, that would be good for me to read it. That would be awesome, even though... Okay, but thank you very much. Ross DeAngelis, is that you?
No, ma'am.
I believe we have a David Levon.
What happened to Ross DeAngelis? Did I take him out of...
Mr. Levon is in Cuba.
Oh, that was the... Did I get confused?
Oh, you gave me a new list?
Yes, ma'am.
Oh, you sure did. Oh, okay, he in the felony DD.
Okay, that's all right. I'll keep him over here.
David. No, yeah, this is the one I didn't take out.
Okay.
I'm sorry.
No. You're fine.
She did
Him.
Yes,
Okay.
And then we'll put him back.
Oh, okay.
Okay.
All right.
I forgot.
David Levon, don't fall. David Levon, is that you?
Yes.
All right, you have 7 counts: aggravated abuse on an elderly person, battery, domestic assault, domestic, criminal mischief, possession of cannabis, possession of drug paraphernalia, and grand theft. I find probable cause. Set your bonds as follows. It's $10,000 on count 1, and then $1,000 on count 2, count 3, and count 4, $250, count 5, the cannabis, $1,000, count 6, the drug paraphernalia, $500, and count 7, the grand theft, $500. No contact with the victim, no drugs, weapons, or alcohol, no return to the scene, and don't have any contact with that cat.
And just for the record, he is a risk assessment of below average. He does receive Social Security disability. He's for at least the last 10 years. So we just be asking for a reduction of the bond as to count 1.
All right, thank you so much. Ross DeAngelis. Mr. DeAngelis, he charged with battery by strangulation. I reviewed the affidavit, find probable cause.
Your Honor, just for defense to lay the record, it says the word choke. I guess the very last line, the cop is just doing the conclusory statement of having the hand on. There is no allegation that they've lost breath that's required for strangulation. So we'd be asking for just PC in terms of the misdemeanor domestic violence.
All right, thank you so much. It is part of the affidavit that he's swearing to. It's the affidavit part that I'm supposed to rely on. And so I will include that sentence, and with that, find probable cause. I'm going to set the bond at $10,000. No contact with the victim, no drugs, alcohol, weapons, no return to scene, no contact with the cat, and we have somebody here. Tell me your name.
Caitlin Carney.
All right, what would you like to tell the court?
It was a complete misunderstanding. I was drunk. I overreacted. I called the cops. I have been with him for 6 years. I love him more than anything. He doesn't hurt me. He has never hurt me. You can look at me like he has never, ever touched me.
All right, anything from the state or the defense?
In terms of from the defense, we'd ask for no hostile contact. He also has a risk assessment of below average. He's employed full time. He has been for the past 4 years. He is a graduate of college. $10,000 again is tantamount to no bond. It's a presumption of non.
All right, I'll lower it to $5,000, and I'm leaving the conditions the same for now. All right, thank you so much.
Thank you.
All right, Omar Jones. Omar Jones. All right, you're here on account of battery by strangulation, domestic. I reviewed the affidavit, find probable cause, set your bond at $5,000, no contact, no drugs, alcohol, weapons, no return to the scene. And ma'am, are you here for this case? Would you like to be heard? Tell me your name.
Linda Tomasulo.
All right, what would you like to say?
He has no one here, and I just want to make sure he doesn't return back to my home. He has no family, no friends, so I just want to make sure he doesn't return back to me.
Yeah, I'm ordering him no contact, no return to scene, no drugs, no alcohol, no weapons. Yes, absolutely. That's what I'm ordering today. Okay, you understand that?
Yes, ma'am.
All right. Is there anything else I can order him to do for you? Besides not contact you, not go back to the scene?
Just make sure he contacted my mom today, and I just want to make sure.
Oh, yeah, no contact with any of her relatives. Don't contact anybody. That means no contact means you can't even call her mother. Don't contact anybody. And you know what else? Don't post any social media towards her either. Do you understand? Don't announce to anybody any communication. Don't write a secret note to her and put it in your pocket. Do you understand? That's what the no contact means. Does that make sense? Is there anything else I could do for you? No. All right, good luck to you.
Thank you.
All right. tell me your name, sir?
Cody Clevenger.
All right. You're here on account of battery, domestic. I reviewed the affidavit, find probable cause. You're to set your bond at $2,500. No contact, no drugs, alcohol, weapons, no return to scene. I see somebody's here for you. Ma'am, tell me your name.
Justine Smith.
What would you like to tell us?
I just wanted to make sure that his family won't contact me. It's not his fault. He was in jail when they did, but his sister texted me and told me.
Yeah, get your family to stop doing that. Okay? So the same thing goes for you. When I say no contact with the victim, that means no contact. Don't post anything on social media. Don't tell somebody else a message to tell her. Don't write her a note on a piece of paper and put it in your own pocket. No communication, no contact at all. Don't even think about a mental telepathy message to her. Do you understand what I'm saying?
Yes, ma'am.
All right, good luck to you, sir. His name is Cody Paul Clevenger.
Excuse me?
Yes, anything else I can do for you?
Well, he has something he got in trouble before, and I just wanted to make sure that he's not going to get any more trouble. What happened was bad, but I don't want him to get in a lot of trouble because it wasn't as bad as it seemed.
Yeah, all right, we got it. Thank you so much.
How much was his bond?
His bond was $2,500. All righty. Dondre Jasper.
This defendant was here yesterday. There's a note I need you to read.
Okay.
PTR yesterday, but we're asking you to read the PTR.
He gave him a bond. They have
Okay, and Mr. Jasper?
Yes.
Your pretrial release is revoked, and I'm setting your bond at $8,000. No contact with the victim. Did you hear what I just said?
Yes, ma'am.
All right, that means the same thing to you. Don't think about her. Don't write secret notes and put them in your pocket. Nothing. Nothing, nothing, nothing. $8,000 bond, no drugs, no alcohol, no weapons, no return to scene. Thank you so much.
Just for some clarification, the one case that he's here is for the CF case that we dealt with yesterday, had 2 counts, battery by strangulation and battery domestic violence. I know you're revoking PTR, but is the $8,000 to the strangulation?
Yeah, no, I have the violation of injunction charge.
Yes, he's going to be seen tomorrow.
Yeah.
It's an add-on charge.
So the violation of injunction, that's what
Let
we
me
have.
see. He's supposed to be seen today on the violation of injunction.
I have the violation of injunction.
Right, that's what we got.
Right. And then with the battery strangulation, we need bonds set on that as well.
You want that now?
Yeah.
We don't have it.
Okay, he was seen, okay, I have,
So-
he was seen yesterday.
So you want to do it tomorrow?
14th.
Wait a minute, let me see. Jasper, let me see if I got him in
It
the
was
back.
straight PTR he was given yesterday.
What's the case number?
2018 CF 578AO.
Ms. Martin, can I address that case now?
Yes, we would just be asking for bonds to be set on the 2 counts. It was
All right,
battery
so
by
it's
strangulation.
$8,000 on each.
So on all 3 counts, the injunction, the
What's
strangulation.
What's the felony?
What's the third count?
Well, so. the
2
CF
cases, 1 case had 2 counts.
Right, battery by strangulation, a 3rd-degree felony, and battery domestic violence, a misdemeanor. In the
Yeah,
first
that
degree.
one's 500.
500, okay.
So 8, 8, and 500.
8. So this injunction is 8.
This is 8,000,
Battery
then his
strangulation.
strangulation is 8,000, and then the simple battery is 500. All right, so Mr. Medina, I reviewed your affidavit, find probable cause, set your bond at $5,000. No contact with the victim, no drugs, alcohol, weapons, and that's all.
Your Honor, just for purposes of the record, he does have a risk assessment of below average. He's employed full-time, has been for 9 years. He's also former military.
All right, I'll lower it to 3,000.
Okay, and would you be willing to do or PTR if he qualifies? He does indicate that he would qualify and would have an alternate.
Not without having it seen before a judge.
Okay.
All right. All right. Denise Narvaez, sorry. Miss Narvaez, you are here on a battery charge, and I see somebody's here for you. I reviewed the affidavit, find probable cause, set your bond at $3,000. No contact with the victim, no alcohol, no drugs, no return to scene. Do you guys live together? Yes. All right, so instead of no return to scene, it will be must keep separate residences. All right, so that is my order for now. Let's see who's here. What's your name, sir?
I'm her husband. May I say that she's an amazing woman, amazing mother, amazing wife. She did not deserve this. I made a mistake and I called, and I shouldn't have. We should have resolved it, which we always do. And she does not deserve this. Please have mercy, please.
All right, thank you so much. Anything else, Ms. Martin or State?
Well, I would just ask, do you want to have contact with her?
I'm sorry?
Do you want contact with her?
Yes, ma'am,
Are
please.
you currently in fear of her?
I'm sorry?
Are you in fear of her?
No, definitely not. No.
Defense would just ask for no hostile contact. It also does indicate that she qualifies for pretrial release. I'm guessing it's the same as the others, is that as long as there's
Your Honor, if you give her no hostile, we can do pretrial release for Ms. Navarez.
All right, I'll do no hostile contact and then pretrial release. No alcohol, no alcohol, no alcohol. Okay. All right, and Jason Ortiz, Mr. Ortiz. All right, Mr. Ortiz, you're here on a battery domestic. I reviewed the affidavit, find probable cause, set your bond at $3,000. No contact with the victim, no drugs, no alcohol, no weapons, no return to scene. This concludes your hearing. Good luck to you, sir.
Thank you, ma'am.
Mary Perry.
And Your Honor, just so you're aware, Ms. Perry and Mr. Perry were both arrested.
Yes, I see that. I drive hotel something something.
They both qualify for pretrial release. My understanding from speaking to them is they both want no hostile contact. The guard is asking me if you want both of them present so that you can get the testimony about no hostile contact, or if you prefer to do them one at a time.
Well, he's here on, let's have him together since he's here on her case and I presume he's here on his case.
Right.
Right. So first we have Mary Perry. You're here on a battery domestic. I reviewed the affidavit. She does, so they qualify for pretrial release. All right, I'll give you pretrial release. No hostile contact. Is that what you want?
Yes, ma'am.
And Mr. Todd Perry, you want contact with her?
Yes, ma'am.
All right, no hostile contact, no drugs, alcohol, no alcohol, no alcohol, no alcohol, no drugs. No hostile contact, no return to the scene. I don't think they want you to come back.
Sorry, man. We don't have to. Our daughter's already taken care of getting all her stuff in our car out of there.
All right, great. So same thing for you, Mr. Todd Perry. Is that what you want, Miss Mary Perry? You want contact with him, just no hostile contact. All right, no hostile contact, pretrial release, no return to that iDrive location. Good luck to you all.
Thank you, ma'am.
Thank you. All right. We have next Mr. Armando Carrillo.
Your Honor, he wants, I guess my assistant today, but he wants to hire a private attorney for
All
the
right.
case, so we just asked not to be appointed.
All right, so no appointment, and
Now, I would just note that he does have a risk assessment result of below average. He's employed part-time and has been for 5 months.
all right. I reviewed the affidavit, find probable cause for your destruction of evidence, tampering, and drug possession of a controlled substance without prescription. Find probable cause, set your bonds at $2,000 for count 1, $300 for count 2. This concludes your hearing. Good luck to you, sir.
Your Honor,
Thank
he's
you.
also here in an expired driver's license.
Oh, hold on, you're right, I saw the paper clip. And find probable cause on the expired driver's license based on the affidavit and set your bond. That bond seems high. I'm going to reset it for $500.
Thank you, Your Honor.
Okay. All right. Next is Timothy Jones. Mr. Jones, good morning. You're here on a possession of cocaine, and
My understanding is he qualifies for pretrial release, at least that's He does.
all right. Driving with a suspended license and possession of cocaine. Find probable cause and order pretrial release. No driving without a valid driver's license.
Yes, ma'am.
All right. And Alan Lloyd, possession of cocaine, possession and trespass. I reviewed the affidavit, find probable cause, set your bonds at $1,000 for count 1 and $100 for count 2. Good luck to you, sir. Nicole Michaud. James Poindexter. Is that you, sir? All right, carrying a concealed weapon, unlicensed firearm. I reviewed the affidavit, find probable cause, set your bond at $2,500.
Well, Your Honor, I believe he qualifies for pretrial release.
Does he?
Yes, Your Honor, he does.
All right, I'll order pretrial release. Good luck to you, sir. Rhonda Webster.
That'll help, Your Honor.
Kristen West. All right, Miss West, you're here on a new case for driving with a suspended license. This one. Rhonda Webster's mental health, right? All right. And Kristen West, you're here on driving with a suspended license as a habitual traffic offender. Review the affidavit, find probable cause, set your bond in that case at $5,000. And your old cases, 17 CF1 0443AO, I'm revoking your bond in those cases. This concludes your hearing this morning. Good luck to you, ma'am. All right, Austin Wingington. Is that you? All right, you're here on a charge of possession of hashish. I reviewed the affidavit, find probable cause, set your bond at $1,000. This concludes...
I have an indication that he qualifies for pretrial release.
He qualifies for pretrial release, Your Honor.
All right, I'll order pretrial release in your case. All right, good luck to you. Fabian Wilson. Thank you. Robert Young. All right, Mr. Young, you're here on 3 counts, possession of a forged driver's license, bank bill, and driver's license ID card. Those are the 3 counts. I reviewed your affidavit. Find probable cause, set your bonds as follows. Count 1, $2,500. Count 2, $150. Count 3, $150. This concludes your hearing. Good luck to you, sir. Jamal Brown. Mr. Brown, good morning. How are you?
Good morning.
All right, looks like you failed to appear on 2 cases, and the bonds are set in these cases at $2,000 each. 2 counts. 2 separate, battery and assault you failed to appear for. So now your bonds are $2,000 in each of these counts in 2017 MM1259AW. This concludes your hearing. Good luck to you, sir. We have Giovanni Burgos. Mr. Burgos, you're here on a no valid driver's license charge and attached tag not assigned.
Your Honor, I apologize, just 1 second. There was an offer from the state. He is on pretrial release out of Orange County, but the state's in agreement to take no action on that. That's what defense would be asking. The offer is for the no valid, to withhold credit for time served, and to dismiss the attached.
You want to do that, Mr. Burgos?
Sure.
Did you fill out the plea form?
What attached tag? That's the Osceola case.
That's the Osceola case, that PTR.
That's the Osceola.
No, the Osceola case is the MM petty theft.
Right.
This right here, yes.
And then what they want to plea out is the Orange
Oh,
County
you got
cases,
2.
no valid driver's license, and attached tag not assigned. So the state's going to dismiss the attached tag not assigned, and you're going to plead to the 2nd-degree misdemeanor of no valid driver's license, right?
Correct.
And then we're not going to take any action on your petty theft case that's pending in Osceola. Did you read the plea form?
Yes, I did.
Do you understand the form has all the rights you're giving up today?
Yes.
And what is it, a withhold court costs?
Yes, Your Honor.
All right, you want to accept the withhold court costs to resolve your no valid driver's license charge?
Correct, ma'am.
Anybody force you to do this?
No.
You have any questions?
No.
All right, I find you understand the rights you're giving up today in exchange for this plea to the no valid driver's license. Sentence you to withhold court costs. Your court costs are $301. I'm going to give you 300 days to pay. Is that enough time?
Correct.
You have 30 days to appeal this sentence in writing. I'm going to dismiss the attached tag at the state's request, and your Osceola petty theft is still pending. All right, so make sure you stay in touch with the court on that case.
The next court date for that is February 9th. I just gave that to you.
Wonderful. All right, good luck to you, sir. This concludes your case and hearing. Eric Mins? All right. Cammie Walker?
Yes, ma'am.
Hi, Ms. Walker. You're here on a failure to appear on a probation violation for a DUI. So now, let's see. It looks like there's no bond in your case because you didn't show up.
And Your Honor, for the record, we would just be asking for a bond to be set. There was a motion to quash filed on January 12th, which was when the failure to appear occurred. It seems that she showed up late, so we would just be asking for a $2,000 bond to be set in this case.
Are you saying that the bond was issued in error?
No, it appears that by the time the court was done, the failure to appear case was done, but then a motion to quash was filed by our office that same day, just a little bit later in the day.
When? What day?
On January 12th.
Oh, really? They came and got you that fast? All right, I'll set your bond at $2,000. All right, thank you, Ms. Martin. All right, William Smith. Mr. Smith, you're here in a trespass charge. I reviewed the affidavit, find probable cause, and set your bond at $500.
Thank you, Judge.
Thank you. Good luck. Vincent Garofalo.
Your Honor, I'm sorry, was there an offer from the state for Mr. Smith?
You have an offer for Mr. Smith?
One moment, Your
Is it a
Honor.
withhold court costs for the trespass? I think that's what you said, no? Is that, you want to accept the state's offer of a withhold court costs? Or do you want to
Say that again?
You can post your bond and fight the charge, or you can accept the state's offer. I think I heard her say withhold court costs, which is $273.
Yes, Your Honor, the offer would be a withholding court cost, just confirming his record.
All right, you want to accept the state's
Yes,
offer?
Judge, I accept that.
All right, and you have to fill out that plea form. Do you understand that form has all the rights you're giving up today?
Yes.
Anybody force you to enter a plea today?
No.
All right, you understand that you're not going to have a trial, you're not going to call any witnesses, you're not going to make the state prove the case against you beyond a reasonable doubt. You're pleading to this case and you're giving up all those rights. You understand that?
Yes.
All right, did you sign the plea form? All right, I see you signing it. Anybody forcing you to do this?
No.
You sure you want to do it, right?
Yes.
Any questions?
No question.
All right, I find you understand the rights you're giving up today in exchange for this plea. I find a factual basis to accept the plea based on the narrative and the arrest affidavit. I'll accept your plea and impose the following sentence. If Natasha is still the court reporter, I'm sorry I'm talking so fast, but she should know already. I'm so sorry. Okay. I'll impose the following sentence of a withhold of adjudication and court costs. Your court costs are $273. I'll give you 300 days to pay, and you have 30 days to appeal this sentence in writing. Good luck to you, sir.
Thank you.
Thank you. All right. Vincent Jr. Garofalo Hospital. Resets. Christina Giardo. Is that you? All right. Possession of heroin, possession of cocaine, possession of drug paraphernalia. Find factual basis. Set.
Your Honor, this was a reset from yesterday for the state to get more probable cause. It was just a blanket statement within the four corners of the affidavit that the officer is charging her with those 3 counts. There's actually no facts or indication of substances that looked like it, training experience that identified it, or presumptive tests. And I believe the state was going to talk to the officers about that.
Your Honor, the state has reached out and has received a narrative from the officer, Bertha Osorio. Because the records office is closed today, though, we were not able to get the signed and sworn affidavit version of the narrative. I have a copy for your record to indicate that we do ask for good cause for 24 hours to get that sworn statement.
And there would be no objection to resetting this again based on that because it
Okay.
does
Reset for tomorrow. Thank you. Jamie Lambeth.
Yes, Your Honor.
All right, good morning. You're here on battery, domestic violence.
Your Honor, I can explain this case. He's a reset from yesterday. We had a condition that he wasn't supposed to return to the scene of offense, but the victim has moved out. We do have a notarized letter stating where she is presently residing. So we're asking if you can just delete the do not return and that he can return back to the address where the incident occurred.
All right, it's instead of do not return to the scene, it's going to be keep separate residences, okay?
Thank you.
All right, good luck to you, sir. Precious Love. Ah, Precious Love. I was really looking forward to meeting her. Henry Porter. Okay. Ernest Powell. Is that you?
Yes, ma'am.
All right, Mr. Powell, you're here on account of open container and the state's offer. Is there a state's offer? Withhold court costs?
We have to remember. Oh, yeah, that's the one.
This is the one where we do, instead of no return to scene, we keep separate residences.
Yep.
Okay.
Precious Love was mental health, right?
Yeah, or refuse, mental health or refuse? Mental health,
And
okay.
Mr. Porter.
Mr. Porter was refused. All right. Oh, withhold court costs, state?
Your Honor, he's actually asking to take this case to trial, so we just ask for, I don't know if you would call
Does he qualify for pretrial release? No?
No.
All right, your bond's $100. William Joseph Rome.
Mental health, Your Honor.
Okay, and last but not least, Mr. Vance. Burglary and grand theft.
Your Honor, I didn't have an affidavit for this.
We've been trying to type in Polk County to come pick them up. They haven't responded. I called today. Their office is closed until tomorrow. So
You want to reset it for tomorrow so you can call? All right, we're going to reset your case for tomorrow so that the corrections can call Polk County. All right? Good luck to you, sir. All right, court's adjourned. Let's get back on the record Mr. Vance's case. What's up with Mr. Vance's case?
he's been trying to serve ever since January the 6th. And we've been trying to type in Polk County with no, they haven't made no arrangement to come pick them up.
What's the Polk County charge, Miss Martin?
I'm not sure, I don't have any.
I know it.
Why don't you tell me in my ear? Where my understanding from when I used to do eyes in the day is if they don't come pick them up, they have to be released, and then they're just told that they want to go check in with that county. But he's indicating it's a simple grand theft charge, a third-degree felony.
All right. And
Release him on ROR, and it is up to him to go to that county to satisfy his
I
case.
can report.
is that the charge? But we don't know the charge. He's telling us the charge.
That's
So I would
correct.
reset it for tomorrow. If I had established proof besides coming from the defendant that it was, is it in there?
It's a grand theft charge and a resisting. That's it.
How old are you?
I'm 24 years old.
And you've been in here since January 4th, waiting to go to Polk County?
I've been in here since September 5th, 14th. I came to jail.
All right.
I was released
and-
January 4th.
And there's no pretrial release because it's not our case, right? Is that how it works?
So normally how it works is...
Can I set his bond? Can I give him a bond? No, because
no.
it's not my case. It's not our county's circuit's case.
Right, and normally how it happens is when another county picks them up, if it's a county that's touching Orange County, they have 24 hours to get them. If they don't, then we're supposed to release them unless the county gives an indication as to why they need an extension. If it's a county further away, it's 72 hours. I don't remember if Paul touches Orange County or not, but it seems like he's expired regardless, so we have to release him, and if that other county didn't pick him up, and he just needs to make sure he goes there, he's going to get another warrant.
I'm just wondering why it's being addressed today as opposed to every other day.
My guess is the time lapse. They don't do these over the weekend, so this is probably, since it's a Monday, it's here. But normally, if they're not picked up at the requisite time frame, they have to come back to court. So,
But today's the 15th,
exempted in since the
So he was
4th.
picked up on the 4th.
He was not served on the 4th. I guess they've been notifying.
So what-
With no response.
I mean, how many days did we wait? That's an extra week.
It seems like he probably should have been brought back a lot sooner if the dates are correct. So, I mean, Polk County has the option to get him. If they're not coming, this county can't hold him. They would have to
All right,
replace him.
State, what's your response?
Your Honor, we would request that this be reset for tomorrow so that we can have some time to figure out what the actual timeline would be and why it's been so long.
You want to research this issue between today and tomorrow to figure
Well,
out?
to reach out to the appropriate,
You're going to try and call the state attorney's office in Polk County and let them know that they have a defendant here that they have to transport over there and that that's not been done?
yes, Your Honor.
All right, I'll reset it one more time till tomorrow.
Hey, if you love watching what's happening inside courtrooms, there's no better place than Court TV, because Court TV is back. We are relaunching May of 2019. Stay tuned for local listings. I'm Vinny Politan, anchor from Court TV. And yes, Court TV is back. You didn't know we were gone? Well, even if you didn't know we're gone, we're back. May of 2019, the network relaunches.